My lord, I like to pray for listing of an urgent matter.
Go to court number 8. Court number 8 is senior court.
May I please, Your Lordship? I beg to mention item number 11. With the consent of the other side, Your Lordship may grant us a week's time to file our objection.
Short time may be given, Lordship. I am the petitioner, Lordship. It may be weak. Short time may be given. Earlier, last occasion, LCR also called for.
Please, your good name?
R. Hussain, Your Lordship.
R. Hussain.
Yes, Your Lordship.
Learned counsel liability on behalf of Sikaya. Conduct of press for granting our complaint. Able to file objection to the better pick.
20 or 21 maybe.
May I please, Lordship? Lordship, yesterday I have filed affidavit in opposition in connection item number 41, Lordship. Kindly allow me bring on record of you.
Wait, please, Your Lordship. With consent of the other side, I beg to mention item number 4, my lord. In this case, I was supposed to file a reply, my lord. So within 2 weeks, I shall file, my lord.
Mr. Sahu Lorde which I to file reply.
Reply.
There is allowed. Let the cell the matter. After 1 week.
2 weeks, my lord.
No.
Yes, please, Your Lordship. My lord, with
Public.
the consent of the other side, I beg to mention item 1 of today's list, my lord.
Yes.
My lord, can it be taken up on 28th of August, my lord? There is a little difficulty. 2/8, my lord. 29.
On the affair being made by Mr.
J. Bora.
J. Bora, Karnataka Bora,
Richmond.
appellant,
Appellant.
I am pro forma respondent.
with consent from the other side, as for the 8 of 29th of
August.
there is allowed.
So there is an interim which may continue till
Third
then.
order authority.
Briefly.
Please, Lordship, item 38, my lord.
Party,
38. My lord, the arguing counsel is out of station due to some medical problem. My lord.
your name,
Adjournment. My lord, K. Ahmed.
yeah.
Yeah.
Learned counsel for the you involve the other side.
Yes.
After 1 week,
My lord, next week. Any day.
May it please Your Lordship, I beg to mention item number 40, my lord. Lordship, in this matter, although service has been completed, my lord, the respondent have not entered appearance, my lord. This matter may kindly be taken up after 2 weeks, my lord. Item number 40.
Bora,
B. Bora, my lord.
learned counsel for the submits the service in petition as
By way of Dusty, my lord.
by way of the
On 24/6/2025.
as the matter for admission hearing.
Yes, my lord. After 2 weeks, my lord,
After 2 weeks, they are allowed till the interim order
interim order.
started.
Date?
Yes,
Any date, my lord? September 1st week? 8th September, my lord. 8th. I'm deeply obliged.
May it please, my lord. My lord, with the consent of the other side, I beg to mention item number 2, my lord.
item
Number 2.
Two.
I have informed Mr. H. Das and the counsel appearing for I pray for an adjournment today, my lord, on the ground that Mr. B.D. Dekka is unable to.
the other side.
I have informed Mr. H. Das.
Mr.
H. Das, I have informed.
Your name
And chosen.
and Chaudhary learned counsel for the petitioner with consent from the other side. After
After a week, my lord.
after we prepare the
Interim order is there, my lord, which may be
interim order author.
deeply obliged.
If I may, my lord, I pray for an adjournment of this matter today, my lord.
Pardon?
I pray for some time on this matter. It may be adjourned for the day. My lord, due to the fact that, my lord, the conducting counsel, Mr. A. Iqbal, he's unable to appear today due to incessant rain. There's been some flooding in his area.
Otherwise, Your Lordship, they were supposed to file a reply to my affidavit. I filed an affidavit in this matter to bring on record certain additional facts about my bona fide requirement. So they were supposed to file the reply on the last occasion.
They?
The respondents. So whether I don't think they filed it yet.
No, they may file it or may not file it.
That is it.
The court cannot compel.
Uh-huh.
But sir, is also learned. Sir,
G Imtiaz, man.
the
Imtiaz.
MPS learned counsel appeared via A but Mr. MPS submits that conducting counsel Mr. A but not remain present in court and rest for adjournment of matter for the day where out this appear after 1 week.
Your Lordship, a date can be fixed and the matter can be disposed.
Okay.
20. Obliged.
Deeply obliged.
Sometimes the it has not, it is after some.
None of this sort of it's not a cost, it's a matter of none of this sort of what it's about.
Your Lordship, here in this case, what happened? I am not the party in the suit, my lord. I am not in the party in the suit. The plaintiff respondent filed suit against the one Om Prakash Nandilia for excessive performance of contract.
You are not a party.
Not a party.
Then
Application was
how you can
application he has filed. Application he has filed. That application is here. I have annexed. But the court has not implemented me till date. That application was kept in abeyance because he filed the composite application for implementing me, also for amendment. That application, Your Lordship will find here, page number 55, 9. This is the application, my lord.
Page number?
Page number 55. This is the application.
You have
Yes.
completed.
I was not implemented. This application, Your Lordship will see, was kept in abeyance because another application was filed. That is why Your Lordship will turn to the page number 60. Your Lordship will find here a copy of the order dated 6/12. Here, the another petition. This is the 1405 is that application. Under order 1 rule 10(2) order
Number,
6.
next page number.
Next number 60. I am, my
60.
lord, I am referring 60 page number, my lord. Here the court kept this petition in abeyance. Here, my lord, Your Lordship will find that seen the another petition number 1405. That application is the application for implementing me under order 1 rule 10(2) and order 6 rule 710 read with section 150-160. Copy of both the petition are received by the learned advocate for the defendant. Defendant here, at that time, I was not appearing. The further proceeding of this case is kept in abeyance till disposal of the petition number 1404. Is it another application? Till disposal of that application, that the application seeking to impede me was kept in abeyance. Thereafter, what happened? He filed the application for injunction against me without impleading me. That application you are allowed to find. That application is page number 30. Page number 30. Page number 30. Your lordship will find that application. And here your lordship will find my name. I am Siddhartha Borua.
Page
Here,
number 30.
yes, 30. An application under Order 39, Rule 1 and 2, read with Section 151. PPC. That application, your lordship will find my name here, page number 31, Siddhartha Borua. The original defendant died. After his death, Nilakshi and Sangamitra Sandhya was impleaded. Here, they are the party, actual party, Nilakshi and Sandhya. And along with them, I'm also impleaded here, Siddhartha Borua, whereas I'm not the party in the suit. I'm not the party in the suit. And this common your lordship will say, page number 29, that is also in the Mish case. This case was registered as a Mish case, Mish J case number 5722. That injunction application was registered as Mish J case number 5722. That your lordship will find this notice also here, the page number 29. Only in the Mish case, Mish J case number 57, that notice was issued to me, Siddhartha Borua. Here, Siddhartha Borua, my lord, he entered into an agreement for purchase of the land. That, my lord, the question was delivered to him in respect of the 3 kata 15 lisa land. And he paid a substantial amount of that to the actual owner. And the plaintiff also claimed, my lord,
in the Mish case,
Miss,
you
yes,
were
Miss J case.
allied as a party.
Yes. But
So you have not been allied in the main suit.
I am not the party. Apparently, I have annexed all the documents. I am not the party. So the question is whether a person who is not a party in the suit against whom the injunction can be granted. Definitely not. There are several decisions, your lordship. I want to place those decisions here. Supreme Court categorically stated that if person is not a party,
Let notice go at it.
my lord.
Let notice go at it.
Yes.
Let the other side appear.
So, my lord, in the meantime, that order may kindly be stayed because order is apparently your lordship will see these
Like
as
Learned counsel for the appellant. This appeal under order protected 1R. It's directed against the order dated 14/5/2025 passed by the learned judge. Dated 2009. Of the learned by the learned judge denied the petition allows the petition file under order 31 and restrain the opposite party number 3 from by court And 4, creating disturbance conflict and joint over the city during the pendency of the case. There is a memo of evidence at the ground notice of the be taken by research after by the part this application under one part by the applicant of the operation time ordered or by part civil justice in the case for is considered and by order dated the civil justice of the central it's the vital learning concept for the applicant subset. The applicant herein is not a party in the title of number 13 of 2019. So, notice was issued to him in the case number 57. Mr. Upaidhya further suggests that the applicant herein had filed one petition order was wrote that under order 1 rule 10 and order 670 to check on 150 before the learned civil justice but by order dated 6 the learned civil justice has kept the further proceeding of the title in abeyance it was put that of the petition number 1424 of 2020 and 1405 of 2025 under order 24 for substitution of legal heirs of the deceased and also under order 1 to 10 and order 6 7 but without passing an order on the petition for 1 to 5 of the filed by the learned civil judge and first the order and if the applicant is not a party in the main title to the order, the impugned order is not binding upon that the Mr. Upaidhya has stated they offers order dated till of this affair. And I have heard the sub Mr. Upaidhya and for the applicant I have the applicant that appears that the petitioner the applicant here is for a party that like and on 6/6/2025 the order was dead and order 6/7 but the same petition that and without disputing the learned the security also in order for 5 5 allowing the application for the third. Thus, the gets agrees to be that the program that according to the order they then they did return a it's after 4 weeks.
Hello.
Yes.
Resemble earlier 3 occasions respondent has not appeared, madam. So color number file, madam. There was the earlier order, madam. 3725. It is civil revision petition. I have challenged the Malad impugned order 29/7/20.
Was fine.
Well,
But
and his name also reflected in falsely also, madam.
the name that
Madam.
Item 9 and 10, Mr. A.K. Gupta is appearing. Kindly after some time, Lordship. 9 and 10 both.
I can say both.
Both after some time, Lordship. Obligation.
May it please your lordship, my senior is on legs in another court. Kindly pass over the matter for time being. Problem.
Where is your lordship? Lordship, I may be allowed to withdraw the matter of liberty to avail other legal remedies, my lord.
Or Mr.
P. Saikya, my lord.
P. Saikya.
Yes, my lord.
Sir,
DK Bakshi.
DK Bakshi.
DK.
DK Bakshi. Sir, so just not what's that. Yes, I recommend. According to this topic, plastic paper away other
Legal remedies.
legal there are yes.
What's your pleasure?
May it please your lordship, the matter may be passed over for a time being. Learned counsel G. Bordello is at desk. Okay.
Lord, it may be taken after some time, madam. Mr.
I am for respondent. Last occasion, my lord, kindly see the last order.
But it is absent.
Yes, my lord.
Not appears to the both of the M of
M. Hussain, my lord.
M.
Respondent number 3, 4, 7, 8, 9, 10, 3 to 10, 9.
List after 1 week, the event of subsequent non-prepared.
Most of the journal.
May it please. The other day, my lord, I have submitted this. And I have also formulated the substantial question of law at page 5, my lord.
The question number 1 may not involve here.
Actually, my lord, in this particular point, my lord, there is no specific decision till now. So I have formulated. Because the cross suit or cross objection, it will be treated as a plain. When a plain, it is a plain, there will be a decree. And against the decree, a specific appeal should be filed. Order 41, Rule 33, my lord, says different. The Supreme Court has discussed in that sense. In some cases, my lord, without filing appeal, court can consider. But here, my lord, one, their suit is dismissed, my counterclaim is allowed. Both are different, but they have filed only one appeal. That's why, my lord, if your lordship, actually, in this point, my lord, a fresh decision is required from our court also. Whether
One decision of Himachal Pradesh High Court is there. There it is stated that it composite appeal can be filed, but additional court fee has to be paid for the counterclaim.
Yes, yes. They have not paid any additional court fee. Really, at the time of final hearing, my lord, it will again come. That's why, my lord, I want to formulate one point there so that it may be decided finally. Because Justice Sumansam, my lord, discarded the facts and circumstances, every case of facts and circumstances are different. As this is a reversal, my lord, one court, my lord, found it proper, and the appellate court, my lord, reversed. And the counterclaim is dismissed without saying anything specific.
So in respect of question number 4, whether the burden was shifted to the defendant.
Page 6, my lord.
No. This issue number 4. Substantial question of law number 4.
Is it true?
Yeah.
Whether the judgment of the law appellate court is justified in passing the decree of the suit without discussing the evidence on record and shifting the burden on the village. Yes, my lord.
Where it is shifted? Which part of the decision?
Yes, my lord. Actually, from page 139, my lord, para 21. The defendant state that, middle, my lord, said that the plaintiff was possessing the RCC house illegally. The defendant admits the receipt of rupees 2 lakhs, but instead that the said rupees 2 lakh was given to as the plaintiff agreed to purchase the 6 lakhs of land along with the Assam type house at a consideration of rupees 17 lakhs, my lord. Once the defendant number 1 admits the receipt of the advance amount and consequent possession of the plaintiff over the suit land, the burden lies on the defendant
to prove their pleaded position. We have proved, my lord. We have fully stated, because the RCC building belonged to my father and he filed WS, but he has not adduced evidence. That is the only thing, because during that time he died. Sorry. He died, my lord.
Then how this question arises?
Because, my lord, the court shifted burden that it is the burden of the defendant to prove. That's why, my lord, I have taken that point. A specific line is there, my lord. Earlier to that, my lord, para 19, page 138, both the parties, para 19, my lord, stated that there is no written agreement between the parties to substantiate the claim. The plaintiff adduced evidence of PW1 and reiterated his stand taken in his plain. PW2 and 3 supported the evidence of the PW1 that the defendant number 1 agreed to sell the suit land and the building in consideration of rupees 8,50,000, and thereafter a check of rupees 2 lakh was handed over to the defendant number 1. In pursuance to the agreement, the plaintiff appellant entered into the possession over the suit land and the RCC house. On the other hand, DW2 supported the evidence of DW1 that the plaintiff agreed to purchase the 6 acres of land along with the Assam type house at a consideration of rupees 17 lakh. In such case, where specific performance of contract is based on oral contract, it requires cogent evidence, which inspires confidence in the mind of the court. After going through the evidence from record, it is proved that the plaintiff with cogent evidence with the advance of rupees 2 lakh was given to the defendant number 1, who agreed to sell the suit land and the RCC building in consideration of rupees 8,50,000. As the proof of the same, the plaintiff stated that the defendant number 1 handed over the possession of the suit land after receipt of the advance amount of rupees 2 lakh. The defendant stated that plaintiff was possessing the RCC house illegally. The defendant admit receipt of the 2 lakh, but instead stated that the 2 lakh was given to the plaintiff, agreed to purchase the 6 acres of land. Our case is, my lord, total consideration is 17 lakh. And oral agreement was that we want to sell 6 acres of land with Assam Type house. But his story is that he constructed the Assam Type house. All these things, my lord, the learned appellate court did not discuss anything, this thing. There are 22, my lord. In view of the above, plaintiff has successfully proved that he paid rupees 2 lakh to the advance amount to purchase the suit land and the RCC house, and the defendant has failed its burden to rebut. It is shifted, my lord. Or in oral agreement, my lord, the court is to consider the entire evidence. And then 141, my lord, page. Learned appellate court observed, my lord, 1, 2, 3, 4, 5, 6 line, my lord. This itself proved the story that the story of the defendant is false. Though the court does not hold the amount of cost of construction of Assam Type house, however, the court believes, that is word is believes, my lord, that the plaintiff has constructed the Assam Type house of the suit land. However, the court does not believe that the plaintiff has invested rupees 3,73,000 in erecting the boundary wall. Accordingly, the point is decided. One party is believed, my lord, other party is not believed by the court. This is a controversy is there, my lord. Court has to actually, in second appeal, my lord, evidence in some questions, my lord, evidence will have to be read by the court also, or one or two lines, my lord. So I have enclosed that, my lord, ground that the burden shifted to
the defendant. That is not correct. Plaintiff, there is burden on the plaintiff also. When the plaintiff satisfied the court that these things were done, then only the burden shifts. Otherwise not. There is no schedule, my lord. That is a oral agreement. Schedule is put by the plaintiff. That's why, my lord, I have taken the ground number 5. That the law appellate court directed the suit on the basis of the schedule of the plaintiff. Where from the schedule came? My story is different. Their story is different. That's why I have filed the counterclaim. Now they are in possession, my lord. But
No, it also outage of the was not described as if
my lord, your lordship, maybe please another point.
where is your line?
Page 113, my lord. Lower court observed, my lord. Para 35. Therefore, in the present suit, the argument of the plaintiff that the plaintiff was ready and willing to perform his part of the contract is nowhere established except the payment of rupees 2 lakh. And my lord, section 16C clearly said, my lord, specific relief performance of a contract cannot be enforced in favor of a person C who fails to prove that he has performed or has always been ready and willing to perform his essential terms of the contract. Here, my lord, nowhere in the plan he stated that he is ready and willing. Only he stated that he applied for the loan and loan was granted. And the appellate court believe this story. Where is the document? Where is the, my lord, proof that he obtained the loan? He must prove it before the court, my lord. That was not done. So, section 16C of the specific relief fully hit, my lord. These are actually, I have formulated, my lord. Your lordship can formulate any other language, in any other language.
And then I will comprovate that part auditor learned
And thus,
update of the direct the dated 30
Character
five
number
six of what declared as by the additional number of what herein after possible for but please allow the appeal and thereby regard the document dated post 1000 but also declared by document post that was yet after trial entitled number 7 18 Where is the memo by the ground there and just suggested the and also where is the judgment of the court of the third trial second ability is not returned for the beach in my registered to 18 register all for the record the learning or below list of there any execution case was filed?
Para 10 of the IA.
petition. Because they are trying to deposit the amount, my lord, in the executing court. And obtain the sale deed, my lord. In that case, my lord, they are in possession, my lord. Let them in possession. Only judgment may kindly be taken.
Or ordered for the epic order for the 5 direct preferred by the applicant is not the judgment by the but whereby the learned or but it allows the applicant and thereby regards the judgment of the past party that of 7 whereby the learned trial court has Mr. Bobita learned of the applicant subject connected second applicant has already also the learned court will then subject the court right the execute that there is a requirement for stay over the is the project of the second. Otherwise, the second referred by the local where taking from the subject part over the or since state will returnable date
My lord, the case is of 2007, my lord. Record may be urgently called for. Otherwise,
already ordered.
Yes.
I am appearing on behalf of AFOC Lordship. I will file affidavit
When
next week. Yeah,
Or
let's
it's
see,
not
okay,
there,
then,
but it- Sir,
Islam on behalf of AFOC.
the burden council job of after 1 week.
It may be fixed, my lord.
Oblige, motion. Oblige, oblige.
none appears for the appellant on both the matter after one day appropriate.
May I please your lordship? The higher application lordship filed at the times of the admission of the RSA lordship. RSA has been admitted lordship, but the stay petition of the higher application 1189. There is no any order. Lordship.
Lordship, we have not been served with the copy of IA. We have not received the copy of IA.
You have not.
We have not served. They have not served
At
us.
the times of the RSA lordship, second appeal admission of that the application has been filed lordship for the IL for stay of the title suit execution
The
lordship.
question is whether it have part the copy is IA step.
No, no.
No.
Not those. At the times of the admission of the RSL, also, we have been filed the IR application also. But the order of the IR also has not been reflected also. That is as for the stay also. Title suit execution.
Part is a copy.
Yes.
Part sir.
B order.
For the application. And also hard mix.
S. Sharma on behalf of B. Chaudhary.
As Sharma learned. It's applicable product for 5. Dated 36. The learned computer or substance is not part of the learned computer part in the computer.
Lordship, we will file our objection.
It's a matter after 1 week and we have time. The computer
Lordship, 2 weeks. We allowed
Mansum.
only for 1.
Lordship, as per order, last order, the appellant was supposed to file.
We have filed
additional
affidavit,
but we have not received.
I can give the copy to him also. This is a case, lordship, where one of the appellant, there are 4 appellants. One appellant, Uday Sharma, has expired. And during lordship, the appeal was filed through an advocate by the appellant. And he was conducting the case, but on the cause list, it is reflected that he was not appearing. Some other advocate was appearing in the case. But the petitioner came to know regarding non-appearance of the advocate, some advocate is appearing. Then he engaged another advocate and he came to know that Uday Sharma has expired. One of the appellants, Uday Sharma has expired and there is a need to substitution. Immediately, lordship, he has filed an application for substitution because 4 appellant is there. One died, appeal will automatically survive. But one appellant, I have to substitute. I have filed an application for substitution with a petition for continuation of delay. And delay is 661 days. And they have filed an objection in the petition for continuation of delay only on the ground. Lordship will find their affidavit. But they have stated
IA number
1521.
Your Lordship, they have not filed any, we have not received any copy. Or they have not served us any copy, Lordship.
Copy has been served, Lordship. Lordship, Uday Sharma, appellant number 2 has died. We have filed 3 petitions. One is for continuation of delay, one is substitution and cancellation of abatement. Lordship, we have filed the additional affidavit as per their objection. They have stated
that we have not disclosed from the month of September 2018 to March 2019. They failed to explain. Lordship, in para 5, they have stated at page 12. What they have stated regarding the delay in filing application. And you see page 12. With regard to the statements in paragraph number 3, 4, 5, and 6 of the instant interrogatory application, deponent beg to filed by the Lordship. Lordship, we have filed. Lordship, kindly see before that objection filed by them, Lordship. Page 11 is the objection filed by them. Lordship, got it? Page 11. Now I will take you Lordship to page para 5, page 12. Lordship, got it? Para 5. It's an affidavit by the respondent, Lordship. Para 5. With regard to the statements in paragraph number 3, 4, 5, and 6 of the instant interrogatory application, deponent beg to submit that the statements made are not at all true. Fact of engaging new set of advocate cannot be denied, but purpose behind the engaging new set of advocate is not explained in the instant interrogatory application. And that is why, Lordship, this court on earlier occasion is directed to file an affidavit, additional affidavit stating the facts why another advocate was necessary. Lordship will find additional affidavit at page 14, Lordship. Additional affidavit as per order of this honorable court. Date 5/8.
5/8 of OCA.
Lordship. 25. 5/8 of 25.
Paragraph number.
Paragraph number 3. Present deponent, Lordship, married. Present deponent along with other appellant engaged advocate R.S. Chauhan for filing the appeal before the Honorable High Court, being aggrieved and dissatisfied with judgment and decree that the demand passed by learned civil judge Nalbari in title appeal number 1, allowing the appeal by setting aside a judgment and decree that the demand passed by the learned Mansit number 2 Nalbari in title suit number Iman. Said appeal has been filed on 23/7/2012 along with IA. Said appeal was listed for admission hearing as the same was admitted on 9/6/2014. Thereafter, appeal has been listed on different dates regarding service of notice. Subsequently, on 30/10/2019, said appeal was transferred to Lojima Court regarding incomplete service of notice. Present deponent, though engaged R.S. Chauhan as their advocate, on verification, deponent found that some other advocates are appearing in the case and nothing has been communicated to the deponent along with other appellant regarding development of the case. Thus, finding no alternative, deponent along with other appellant engaged and appointed advocate R. Sharma to defend their appeal before the Honorable High Court. Thereafter, R. Sharma was engaged by the deponent to see their interest as no communication was received by the regarding development of RSA number 100 of 2014 from earlier advocate. Consequently, deponent along with other appellant engaged advocate, namely R. Sharma, and thereafter advocate R. Sharma called the appellant to know the actual address of the respondents for service of notice. Thereafter, advocate R. Sharma came to know regarding date of appellant number 2, namely Uday Sharma, on 2/11/2016. Accordingly, after knowing the said fact, engaged advocate, namely R. Sharma, informed that since the appellant number 2, namely Uday Sharma, has expired, he should be substituted by his legal heir. So, explanation is this, Lordship. And his objection is that why new set of advocate has been engaged. Earlier advocate has not communicated anything, not informed anything. That is why R. Sharma was engaged. My brother has been engaged. And he has filed application for Lordship substitution of appellant number 2. And Lordship is aware, for not substitution of appellant number 2, nothing will happen. But we have to substitute. That is why we filed this application for substitution. And no harm will cause to them if substitution is allowed.
Your Lordship, without any copies, how can I reply, Your Lordship?
What copy?
Additional affidavit. They are not served us, Your Lordship.
Lordship will see the record. It was served. I can give you another copy to him. I do not understand what purpose will serve by giving objection for substitution of appellant number 3.
They have filed for 2 substitution petitions, Your Lordship.
Yes.
There is two substitutions they have filed. Not only the regarding the appellant number 2, but there is another appellant number 3 also they have filed for.
Yes.
For
Same thing.
substitution.
Other appellants are already there in the record. It will only delay the matter.
Let the matter be released after 1 week, Your Lordship. Let the matter come after 1 week, Your Lordship.
If he enjoying the delay if he enjoying the delay in disposing the matter, I do not objection.
The meantime, appellant number 2 also died.
Appellant number 2 also died.
No, 3 also.
3 also died. Appellant number 1 and 4 is living.
This application is for appellant number 2.
No. 3 also application has been filed for substitution. Separately.
Yeah, what is your objection?
Same objection, Your Lordship. They failed to explain.
They have explained it.
Let me go through with this IA, Your Lordship. Let me go through with this IA because we have received just now only, Your Lordship.
Pardon?
We have just received the IA now only, Your Lordship. They have just served me now.
Tell me after 1.
Look, I have no objection.
Hard because so hard. Your good name, please.
S. D'Souza, Your Lordship. Appearing on the D. Chaudhary.
Lordship, may I leave, Lordship?
Yeah, sir. D. Chaudhary. Learned conducting the learned officer for the response comes that this copy of this interpreted application part that is applied by the less than after 1 week.
Oblige, Your Lordship.
Lordship may fix a date, my lord, otherwise.
Oblige, Your Lordship.
May it please, Your Lordship. My lord,
In this case, my lord, I want to draw your lordship attention to substantial question of law number 7, my lord. That is at page 4. I'm sorry, my lord, page 5. 7. Substantial question number 7. May I read, my lord? Page 5 of memo about. Last paragraph, my 7. Roman 7. BW food evidence today. And stated. Evidence status. BW food to like. Evidence. C. C. BW food C. No, that's 1. But
What is exhibit 4?
the exhibit 4 is the agreement. Agreement for sale. So, my lord, here your lordship would be pleased to see the PW2 is a signatory of the agreement, and it is specifically stated that exhibit 4 is the agreement dated 23/12/2003. Exhibit 4.1 and 4.2 are the signatures of defendant Imanal. Exhibit 4.3 is my signature as witness. So he is witness in the agreement. Now, my lord, learned lower appellate court said that there is no proof that nobody examined who signed when the agreement for sale was executed. But it is specifically said, this is my signature. I signed the agreement as a witness. So, my lord, that is completely perverse fine. PW2 says specifically that on the deed the sale agreement, my lord, exhibit 4.3 is my signature. My lord, finding I am coming on.
Page number?
Page number I am giving you. Last one. Page 17, my lord. 17. 71. Page 71, my lord. Para 33. Page 71, para 33. Your lordship may please to see the middle portion. However, the record reveals that plaintiff failed to examine any person in his presence, in whose presence the exhibit 4 was executed. Page 71, my lord, para 33. The middle portion, my lord. However, my lord, it is a question, my lord. Not, it is irrelevant question, but his evidence is totally silent as to how he became the witness to exhibit 4. That question cannot come, my lord. When he is saying that I signed the, how I have come, PW2 is no need to explain that I come like this. I am the signatory as witness of the sale agreement. Then how that question come? That how I come as witness. So this is a perverse and illegal finding.
There is concurrent finding of fact by both the court below.
Yes, my lord.
Is there any doubt regarding execution of this
My lord,
exhibit 4?
exhibit 4, my lord. I could not follow, my lord. Lord, I could not follow.
Exhibit 4 is the sale date.
Exhibit 4, sale agreement, my lord.
Yes.
Agreement for sale. Specific performance, case is the specific performance. Exhibit 4 is
there
the
any dispute
agreement for sale.
regarding of exhibit 4?
My lord,
Is there any dispute
they
regarding
raised the dispute. They said that I have not executed this. My lord, defendants say that they did not execute this. This is the dispute. On the same date, my lord, agreement for sale was executed. Learned court below, my lord, raised another question that why same boundary? The question is this, my lord, and same day, two agreement for sale executed, my lord, regarding the land, a portion of land and portion of land. So, my lord, on same day, two sale agreement was executed. That is why, my lord, same boundary given. That is the problem, because if supposing on 5th some sale agreement is done, on 6th another sale agreement done, then definitely that portion of land will be shown. But on the same day, so land boundary is same boundary is shown. The only question is this, my lord, that whether sale agreement was executed or not. Quote below, my lord, as I have pointed out, that PW2 says that I am the signatory of the sale agreement. But doubt has been expressed on him, saying that how he become the witness, that is not said. With that view, my lord, learned court below cannot disagree with the evidence of PW2, my lord. That is the substantial question of law. That may be examined by your lordship.
After going to the record, after but IA is also there.
IA is there, my lord, regarding IA is filed not for stay of the judgment, my lord. IA is for that status quo on the land in question may be maintained. Because they claim that they are in possession. My suit is dismissed. So status quo may be maintained on the suit land.
Okay. In the event of admitting the appeal, we will consider that.
My lord. Only call for the records. My lord. Oblige, your lordship.
Bad figure. This is an appeal against an order of temporary injunction granted by the learned trial court. Now, what has happened in this case, my lord? The appellant before your lordship has purchased a plot of land measuring 2 bighas. Now, some dates are important, at least the month. The sale deed was executed admittedly. Well, I'll take your lordship to the documents a little later while I'm just giving the background. In June 2023, my lord, a sale deed was executed admittedly, by which I have purchased 2 bighas of land from the plaintiff. And possession was handed over to me. Then, my lord, July 2023, I applied for retail outlet from the Assam Gas Agency for establishment of a, my lord, petrol pump. The sale consideration was 1.28 crore, my lord. Then, my lord, in December 2023, my lord, I was allotted the franchisee to establish the petrol pump there, my lord. Then, in the entire year of 2024, I have put the boundary wall around the land which I have purchased from the plaintiff, and they were aware of it, my lord. I have made a specific averment in the objection that I have filed against the injunction petition. Then, my lord, I have spent 1.28 crore for purchasing the land, 20 lakhs as a fixed fee to be given to the Assam Gas Agency, my lord. Then I have spent 8 lakhs for conversion of the land into a land to be used for commercial purpose. Then 1.5 lakh I have paid as a signing fee, and then 5 crore, my lord, I have spent for, my lord, digging and putting the 2 tanks, my lord, one for diesel, 30,000 liter, and then 25,000 liter petrol tank, and then, my lord, dispenser machine. After that, my lord, in the month of January 2025, the plaintiff filed this suit saying that the land which I have sold to you as per the schedule of the sale deed is not the land you are occupying.
And so he has filed the suit, my lord, praying for cancellation of the sale deed. And then he makes an alternative prayer. Lord, will kindly have a look at the plaint, my lord. Page 22, man. Prayer at page 30, man. Prayer, Lord, will find at page 30. First prayer is a decree to cancel the sale deed number so-and-so of 2022 and possession of the land by evicting the defendants. This is Schedule D. Then next page, Lord, will kindly see. Now he makes an alternative prayer. Or in the alternative, decree be passed declaring the registered sale deed bearing number so-and-so executed in favor of defendant contains errors that require rectification may kindly be passed. And the defendant number 1 be directed to remain present for execution of a rectification deed or to get the rectification through court's personnel. And along the rectification of the deed, the defendant number 1 need to be evicted from the encroached suit land and to confine them within the 4 boundaries as mentioned in Schedule B. Lordship is seen, my lord. Then there is a second prayer to pass a decree terminating or cancelling the agreement as agreement for sale dated so-and-so 5/1/2024. This is because, my lord, after purchasing this land of 2 bighas, there was another agreement to sell to purchase 1 more bigha of land, my lord. But so far as this petrol pump is concerned, my lord, I have put up in the 2 bighas of land. In fact, I'll show, my lord, within that 2 bighas, in a lesser amount of land, my lord, I have put the petrol pump. Now, this 1 bigha of land for which, my lord, I paid 13 lakhs in, my lord, cash and 7 lakhs through a check. Check somehow got dishonored. And then he has included that cause of action along with this suit, which is not the subject matter of this case. Now, what has happened, my lord? Lord, will kindly see the schedule, my lord, for a moment. He filed the suit. There is a reason, my lord, why he has filed the suit at this stage. Page 32, Lord, will kindly see. Schedule A, page 32, my lord. Sold land with description as in the sale deed. So, in the sale deed, this is the boundary. Schedule B, correct 4 boundaries of the land sold through the deed of sale. He wants to say that correct boundaries should have been as given in Schedule B. Then he gives a Schedule C. This is with regard to the agreement for sale, that is in respect of 1 bigha of land. I am not concerned, my lord. Then Schedule D, which is saying that I am now occupying. Suit land which has been occupied and wherefrom eviction sought. All that part and parcel of land measuring 3 bighas covered by so-and-so, so-and-so. That means 2 bighas I have purchased. Remaining 1 bigha, my lord, I have not yet got possession. But he is trying to make out a case that I have entered into possession of 3 bighas. And he, in the plaint, my lord, he doesn't give any date as to when I have entered into 3 bighas. But sale deed I have annexed. Sale deed for 2 bighas, my lord, clearly says that possession was given to me on 16/6/2023 when I purchased the sale land. Now, there is a reason why he has filed this suit. Because subsequently, page, Lordship will kindly turn to page 125 for a moment, madam. When he realized that it's a lucrative business, he himself has now applied for a similar type of, my lord, franchisee from a different company. Page 125, my lord. Page 125. Now, he has realized that this is because the land is facing the national highway. So he thought, why should I not put up that same business there? So he has made an application on which date? Next page, page 26, if your lordship kindly turns to. This is his application. And he makes this application in September 2023, my lord. Page 126, lordship will find the second table, plot number 1, from Napam towards Jamuguri Hut before Choki Ghat bridge on so-and-so national highway Patta number 101, Dag number 143, same Patta number, Dag number from where he has sold 2 bighas of land to me. Now, Lordship will kindly see the drawing, my lord, at page 168, my lord. Why he has filed the suit, this picture will make it clear, man. Lordship has got, my lord, map, my lord. Now, there is a national highway, 4-lane national highway number 715. My lord, I have given the open area left hand side, my lord, and the name of the plaintiff, Umesh Salma, is there. And the right hand side, greenish, my lord, color, Lordship is seen. He wants to say that your land, which I actually wanted to sell you, is the green land, right hand side. My lord, I have already spent the entire amount for putting up the necessary machineries, etc. in this plot. And after taking possession of the land, I have put up a boundary wall. I have been doing all these works, my lord, as suggested by the Assam Gas Agency, and I have spent my lord, crores. Now, if he can succeed in pushing me to the right hand side land, my lord, then my entire expenditure will go, and I will not be able to put up that, my lord, petrol pump. And now he has applied, and if he gets, he will be able to put up this petrol pump, my lord. Lordship will kindly see at page 170. I have given a photograph also as to what are the, my lord, infrastructure that I have developed in the land. Now, my lord, where after he has filed the suit and obtained an ad interim ex parte temporary injunction of restraining me as well as the Assam Gas Agency from going further ahead with the remaining part of the construction, my lord. My lord, we have filed our objection, my lord. We have raised everything. Apart from that, my lord, we have filed a written statement also and the counterclaim. We have also said, yes, the boundary you have given in the sale deed is a different boundary from the land which you have actually, possession of which you have actually handed over to me. And therefore, my lord, we have filed a counterclaim that the sale deed should be rectified so as to make it in consonance with the land of which possession was delivered to me. Now, it's a question of trial. Ultimately, if he succeeds, then I'll have to leave the land. If I succeed, then I remain here. But today, my lord, after 1 year, after I have spent so much, whether the learned court below was, my lord, within its jurisdiction to grant a temporary injunction restraining me and the Assam Gas Agency from putting up the petrol pump here. That was the issue before the learned trial court, my lord. Now, learned trial court, my lord, has entered into an absolutely mini trial, framed issues. First, we'll kindly have a look at the order, my lord. It starts from page 294, my lord. My lord, from page 294 to half of page 300, my lord, learned trial court has given explanation in terms of order 39, rule 3A, why the learned trial court, my lord, could not dispose of the injunction matter. My lord, and there is a reason, my lord, why the learned trial court has given this explanation. My lord, during the pendency of the injunction matter, initially there was an ad interim temporary injunction, my lord, and we filed our objection immediately. We were, my lord, pressing hard for early disposal of the injunction matter. In between, my lord, the plaintiff has filed an application for amendment of the written plaint as well as the injunction petition. Now, that matter was taken up and the injunction matter was kept aside. We were repeatedly submitting before the court that kindly dispose of the injunction matter. It has got no connection with the application for amendment of the plaint at this stage. And the subject matter of amendment has got nothing to do with the injunction matter. But still the court was somehow not disposing of. And that is why, my lord, initially the court says that yes, I could not dispose of because there are reasons. Because CPC says, my lord, unless there are reasons, it should be disposed of within 30 days. Now, while giving the explanation, I am just pointing out before going to the merit of the case, my lord, the court says that no urgency was expressed by the parties why it should be disposed of. And ultimately, my lord, from page 300, the real case starts, my lord. And I was just pointing out that while the court was considering and devoting at least 6 pages to record the reasons for delay in disposal of the injunction matter, my lord, if your lordship takes up page 295, my lord, page 295. And after this serial number 8, you shall find, however, before delving into the prayer for injunction, it appears to be pertinent to state the reasons behind not being able to pass the injunction order within the statutory period as provided under the Code of Civil Procedure. There is Order 39, Rule 3A. Then, if your lordship kindly turns to page 298, my lord, while giving certain, because amendment, they have paid for amendment, that has taken the most of the period, consumed most of the period. Page 298. In the middle, you will find, to my knowledge, to my knowledge, in the middle, man. Sentence here. To my knowledge, none of the parties submitted any application or made a representation seeking an early or specific date for orders in the present case. The court, learned court, is trying to justify the reasons for not being able to dispose of the matter within 30 days. Now the court itself is saying that none of the parties has expressed any urgency. Then the provisions of Order 39, Rule 3A will be. Anyway, my lord, this is how the learned trial court is proceeded. From page 300, as I pointed out, my lord, the real discussion of the merit of the case so far as the injunction matter is concerned started, my lord. Brief, under the heading Brief Facts of Petitioner Case, man. The petitioner Kulendra Deka states that he and his brother inherited 10 bighas, 4 kathas and 7 acres of land from their father, situated in village so and so. The petitioner, facing financial strain due to his daughter's medical treatment, was approached by the opposite party, who was seeking land for business purpose. Exploiting the petitioner's vulnerable state and addiction to alcohol, opposite party number 2 induced him to enter into an agreement to sell 2 bighas of undivided land without the consent of his brother so and so. The opposite party got the sale deed executed on 16/6/2023, but the actual boundaries and extent of the land sold differed from what was agreed. Later, opposite party number 2 tried to persuade the petitioner to sell another 1 bigha. Though initially hesitant, the petitioner eventually agreed to sell the land for 70 lakhs, receiving 13 lakhs in cash and check of 7 lakhs. However, check bounced due to specific instruction issued by the opposite party number 2 to bank to stop payment, etc. Petitioner informed the opposite party, but they failed to honor the agreement. Relations soured, and when the petitioner's brother refused to join the sale for the additional land, opposite parties trespassed into 3 bighas of land, more than what had been agreed upon, and began illegal construction and land filling. This land included a central portion of the petitioner's and his brother's undivided land, effectively dividing, and these are issues which are not relevant to the subject matter of the case, because sale is admitted. I'll show from the plain panel. Then the court comes below under the heading Order dated 13/2/2025. That was the date when the first ex parte ad interim order was passed. Then down below, accordingly, the court passed an ad interim injunction restraining opposite party number 1 and 2 from making any construction over the suit land opposite party number 3, Assam Gas Agent Company, from granting any permission for construction or establishing a filling station over the suit land till the next date of hearing. Now the prayer of the petitioner. Petitioner seeks an immediate ad interim injunction to restrain the opposite parties from carrying out further construction or alienating any interest over the disputed land, and to prevent Assam Gas Company or any other entity from setting up a filling station thereon pending resolution of dispute. Notably, the injunction pertains to Schedule D suit land. Now, Schedule D suit land is given 3 bighas, boundary has been given. The next comes the agreement for sale. Before this sale deed was executed, there was an agreement for sale for this 2 bighas of land matter. This has been given. Next page, Lordship will find the subject matter of the sale is 2 bigha. Now the court is saying the subject matter of the sale is 2 bigha, 160 feet wide in the western side, portion of larger land holding, measuring 11 bigha, etc., etc. Next paragraph, the total sale consideration is fixed at rupees 1 crore 28 lakhs, out of which 10 lakhs was paid as advance, 5 lakhs by check and dated so and so, and the remaining presumably in cash. The balance amount of 1 crore 18 lakhs is to be paid within 3 months from the date of execution of the agreement. The land is declared to be free from all increments, and the seller undertakes to maintain this status until execution of the sale deed, all expenses relating to NOC. This is regarding, my lord, the agreement to sale. Then down below will find deed of sale. Sale deed executed and registered on 16/6/2023 records the transfer of the land by Jugal Krishna Deka and Kulendra Deka, sons of late so-and-so, as vendors in the favor of Umesh Salma as purchaser. The subject of the sale is 2 bigha of plot of Sali class and covered by so-and-so. Next paragraph, my lord. The total sale consideration was paid by the purchaser in full at the time of execution. The vendors duly acknowledged receipt of the entire amount and affirmed that the land is free from all encumbrances. By this deed, absolute title and possession stand transferred to Umesh Salma, empowering her to effect mutation in her name and to assume responsibility for the payment of land revenue and other statutory dues. Henceforth, the sale deed is properly executed, witnessed, and registered. Then, next paragraph, written objection by the opposite party number 1 and 2. According to the opposite parties, possession of the land sold covered by dag number so-and-so and part number so-and-so was duly handed over to the opposite party number 1. Upon taking possession, they promptly undertook earth filling and constructed permanent boundary walls. During this period, the petitioner and his brother visited the site multiple times, ostensibly to ensure that construction remained within the confines of the purchased land. Subsequently, in response to an advertisement published in the Assam Tribune on 27/6/23, opposite party number 1 applied for and was allotted a franchisee for a petrol pump by Assam Gas Company on 26/12/2023. Construction of the retail outlet infrastructure commenced shortly thereafter in December 2023 and continued up to 20th 2024. The opposite parties further state that by January 2025, construction of the fuel filling station, including 2 dispensing units, an electricity transformer, and 2 underground storage tanks, 30,000 liters for diesel and 25,000 liters for petrol, was duly completed with a total investment of 5 crore. Throughout the development, the petitioner and his brother made frequent visits to the site, observing progress without ever raising any objection regarding the land's identity or extent. It was only when the SSP service station neared operational readiness and the petitioner, without prior protest or provocation, suddenly began questioning the identity of the land, motivations for which remained best known to him. Schedule A of the suit land. As per the petitioner, opposite party number 1 was given Schedule A of the suit land with boundaries given, my lord. Then next, the learned court writes, but as per the petitioner, the actual correct boundaries ought to have been the Schedule B land. They are so and so. It is now appropriate to delineate the core issues that arise during the arguments advanced by the parties. These issues were subsequently reframed into precise questions for the purpose of adjudicating the prayer for interim injunction. Now, issues have been framed as if it is a trial of the suit matter. Whether the acceptance of the sale deed by opposite party number 1 and 2 and possession of 2 bighas of land can be considered valid when the Schedule A boundaries are incomplete or non-existent, particularly in the light of the fact that opposite party number 1's own map confirms only the southern and eastern boundaries, while the northern and western boundaries remain unspecified. This is absolutely incorrect, manner. We have given boundaries, sale deed contains a boundary. This is an issue which is not which is foreign to the subject matter of the suit, my lord. My lord, we are also saying that boundary is not correct, but the fact remains that I have spent so much of money, and in one entire 1 year's period, my lord, I have made the infrastructure, I have spent so much of money. Now you are saying that because of the change in the boundary I am paying in the suit, my lord, which will be decided at the end of the trial, injunction should be granted. Now the court has recorded a finding, my lord. Lordship will kindly see the bottom paragraph, 2 paragraphs, my lord. Such ambiguity raises a bona fide dispute regarding the nature and extent of possession. More particularly, it lends support to the petitioner's assertion that a vital portion of the land space, specifically 160 feet along the western side, allegedly part of the original understanding, was excluded from the sale deed. The absence of the western boundary in the sale deed is not a trivial drafting lapse, but a factor that deserves interim protection until further evidence is laid at trial. So, kindly see the reasoning. Additionally, the fact that counterclaim for rectification was filed only after the petitioner raised concerns suggests that the boundaries in question were neither settled nor mutually accepted at the time of execution. Whether or not the rectification plea ultimately succeeds is a matter for trial, but its very necessity underscores the petitioner's apprehension of injury. Possession to warrant protection at this stage must be linked to an identifiable parcel of land. Here, the uncertainty surrounding Schedule A boundaries creates a floating possession insufficiently anchored in a clear description. What is the English meaning? I don't know. If the injunction is refused in the face of such factual murkiness, it may result in irreversible construction or alteration on land whose land status is still under judicial examination. And the land court is considering an application for a temporary injunction to restrain the present appellant before lordship as to whether they should go ahead with the construction of the petrol pump or not. Now the court is using this rhetoric for what purpose? It is not known, my lord. Next, another issue has come. Opposite party number 1 and 2 contend that if, as claimed by the petitioner, construction on the suit land commenced in 2024, then the petitioner's delay in initiating the present suit until 2025 casts doubt on the genuineness and urgency of his claim. Why did he remain silent for nearly a year despite alleged knowledge of enforcement? Now, my lord, the first paragraph says the contention raised by the opposite party 1 and 2 regarding the alleged delay in filing the present suit is misplaced and oversimplifies the factual backdrop. Merely pointing out that construction began in 2025 does not in itself discredit the petitioner's claim or imply a lack of urgency. Is this the ground on which the court will justify our question that we have raised, that why he did not file the suit in the beginning? Today he is raising after 1 year when I have completed the construction. And the court is saying that it can be discredited. In disputes involving rectification of sale deeds and deviation from the originally understood terms, the trigger for legal action is often not the act of construction per se, but the discovery that such construction is occurring beyond the scope of land mutually intended to be conveyed. In the present case, the petitioner has consistently maintained that the western 160 feet, a portion he considers integral to the original understanding, was wrongfully omitted in the final deed. It is entirely plausible that the petitioner at the initial stage believed the construction to be within agreed boundaries, and the encroachment only became evident upon closer scrutiny. These grounds, my lord, the court is bringing, even the petitioner did not make any averment with regard to this in the plaint or the inactivity. Importantly, this is not a case of complete inaction. Petitioner served a rectification notice in October 2024, several months prior to filing of the suit, evidencing a proactive approach and a genuine effort to resolve the dispute without litigation. Well, I'll show this notice October 2024. It doesn't say anything about the 2 bighas of land. It speaks about the 1 bighah of land on which I have not done anything. The argument of delay collapses further when seen in the light of the opposite party's own conduct. Their counterclaim for rectification was also filed only in 2025, negating any moral high ground on the issue of timing. Litigation is not the first tool of a vigilant party, it is the last. Petitioners resort to legal proceedings only after his rectification plea was rebuffed, so he shows a responsible and restrained approach not a lack of vigilance. In view of the ongoing contest over what portion was actually intended to be conveyed, and with no clear consensus between the parties even now, the issue cannot be deemed stale or extinguished merely because the petitioner chose dialogue before litigation. The dispute remains live, and the petitioner's approach far from dilatory reflects an attempt to avoid judicial intervention until absolutely necessary. And is it a ground to justify why the plaintiff has come after 1 year, and when the defendant has completed the construction of the infrastructure and spent crores, the court is saying that he initially approached by notice, so delay cannot be said to be a delay. These are all, my lord, first of all, my lord, irrelevant issues, absolutely arbitrary. And your lordship is aware, my lord, the almost Supreme Court has said when the appellate court in an appeal under Order 43 Rule 1 should exercise its power and jurisdiction. When the court below has passed an order which is filled with perverse findings, my lord, this subject matter is completely different, and the court is using certain, my lord, literature to justify the point raised by the court itself, and the petitioner has not, the plaintiff has not raised any objection of that nature. Next is, my lord, the opposite party number 1 and 2 during arguments pointedly questioned why the petitioner, despite the sale deed being executed on 16/6/23, remained silent and chose to issue notice for rectification regarding 160 feet only on 21/10/2024. What explains this ordinarily? Well, is this a ground to be considered for the purpose of considering an application under Order 39 Rule 1 and 2? And then next page, page 309, issue number D. Can a buyer's investment of crores in purchasing land justify bypassing the essential requirement of verifying and clearly defining its boundaries at the time of execution of the sale deed? Well, is this the issue involved in the case? Then, my lord, page 310, court has entered into a mini trial which the Supreme Court deprecated, my lord. Page 310, issue number E now. Can opposite party number 1 seek rectification of a registered sale deed not on the basis of what was actually executed, but purely on the basis of her claimed possession, even when such possession contradicts the boundaries recorded in the deed? These are all matters, if at all, necessary to be gone into in the trial of the case when the evidence comes. Then, my lord, page 312, issue number F. Why did the opposite party number 1 stay silent when she supposedly discovered that her possession didn't match the sale deed and only raised the issue after the petitioner sought rectification? Then, down below, another issue number G. Whether the opposite party number 1, having accepted a sale deed that omitted the western 160-foot portion and having remained silent until the petitioner issued a rectification notice in October 2024, can now, for the first time during injunction hearing, introduce the presence of a khatiyandar as a defense to justify deviation from the agreed terms without having pleaded the same in his written statement or counterclaim. Then 315, my lord, the prima facie case has come, which was the main issue to be discussed. Page 315. In the middle, firstly, a prima facie case is clearly made out. The petitioner has produced the agreement for sale, the registered sale deed, and relevant ownership documents to demonstrate that the land presently occupied by the opposite party does not correspond with the boundaries agreed. Notably, the opposite party has, in their written statement counterclaim, admitted that the boundaries in the sale deed are erroneous and now seeks to have the boundaries altered to the effect their current position. This admission, coupled with the petitioner's claim that no such plots exist as per the 4 boundaries mentioned in the sale deed, indicates that the dispute is not frivolous and requires adjudication. In the event the suit proceeds uncontested, there appears to be a strong likelihood that a decree for rectification of sale deed may be passed in the petitioner's favor. Then, my lord, balance of convenience. Secondly, on the aspect of balance of convenience, it is evident that permitting the opposite party to continue construction, particularly of a commercial nature, like a petrol pump on a disputed portion of land would result in irreversible changes. Such acts would substantially prejudice the petitioner's legal position and diminish the efficacy of any final decree. On the other hand, restraining the opposite party from carrying out such construction is only a temporary measure, does not dispossess them or affect their substantive rights, if any, pending final adjudication. Hence, the comparative hardship tilts in favor of the petitioner. And while considering the balance of convenience, the learned court, in my humble submission, ought to have considered that how much of money I have spent and for what purpose, and now whether grant of a temporary injunction will be, my lord, proper or not. That should have been the subject matter of discussion, but that is not discussed at all. Then next, my lord, thirdly, on the issue of irreparable loss and injury. Potential consequences of allowing further construction on the disputed land, especially of a petrol pump, are not only structural but environmental in nature. This is court's case. Environment issue. Court is brought in. Such changes would not only alter the character of the suit but would render any subsequent decree infructuous. The injury caused would not be compensable in monetary terms, particularly if it results in permanent alteration of land use or creates statutory barriers for future use. The petitioner has paid for an order restraining the opposite party from interfering with the suit land. It is pertinent to mention here that this court is not called upon at this stage to adjudicate upon the ownership of the petitioner or opposite party over the suit land. The main issue is one for recovery of possession, and the questions as to who is in possession, whether the petitioner has been dispossessed or whether the opposite party is occupying the land different from what is claimed, are all matters to be determined during the trial of the main suit. However, for such determination to take place effectively, it is essential that the suit land be preserved in its present state, since both parties are asserting rival claims of possession over the Schedule G land, which is subject matter of the instant proceeding. I find it appropriate to direct both the parties to maintain status quo over the suit land. Accordingly, both the petitioner and opposite party number 1 and 2 are hereby directed to maintain status quo as on today with respect to Schedule D land until the final disposal of the main suit. Now, in my humble submission, while considering irreparable loss and injury, the learned court ought to have considered that if after installation of all these materials in the suit land for the purpose of setting up a petrol pump, I have already put in 2 tanks, my lord, of 30,000 liter and 25,000 liter, then other machines. If this injunction remains for 1 year, everything will rust, my lord. This should have been the discussion whether it will rust or not. When you have come after 1 year, there is no discussion on these, man. And my lord, this sale deed was executed by 2 brothers. Only one person has come because he has applied for the petrol pump. And my lord, your lordship is aware that there is a circular manner which says that if a petrol pump is installed in a particular place, within a particular radius, there can be a second petrol pump. So if he succeeds in preventing me from going ahead with this, and he says that no, your land is the adjacent land, because he cannot deny the ownership of over 2 acres of land which he has sold. He has taken more than 1 crore for that. Then he will be able to establish his one. Can the court grant it, my lord? And we have made all these averments in the written statement, and we have in the objection to the injunction petition reflected everything, my lord, with all the documents. And there is no discussion on these relevant issues. Only, my lord.
Mr. Mazumdar, you say,
My lord.
so some irrelevant points are taken account by the learned trial court. It appears that the principal balance of conveyance have been discussed by the learned trial court in the impugn order.
My lord, absolutely. Heading is there. But your lordship will consider whether, while discussing these 3 cardinal principles for grant of temporary injunction, the real issue has been discussed or something which is not pleaded and something which is not the subject matter of the case. My lord, so far as bound.
Is it your case that no prima facie case is there?
My lord?
Is it your case that no prima facie case is there?
My lord, prima facie case for going ahead with the trial is not sufficient, my lord.
No,
for
that's
the
like
for the
standard is much
for-
higher than that.
my lord, for the sake of argument, my lord, I'll say fairly that yes, he may have a primary case to go for trial, but that itself will not grant him, will not entitle him to grant of a temporary injunction unless he.
So that's why I'm asking.
My lord,
is
yes.
your case that no prima facie case is made out for granting temporary?
My lord, for the purpose of the subject matter of this case, I'll say, my lord, no prima facie case is also there. Because while the my lord, court has entered into the question of the subject matter which is to be decided in the trial as to whether this is the land which I'll ultimately get or the adjacent land which I'll ultimately. This is to be decided in the trial. By discussing this, court cannot come to a finding that you have got a prima facie case. Plaintiff has got a prima facie case. The issue here is whether I am entitled to establish and set up this petrol pump in this land when after taking possession of the land, you have handed over possession to me. Plaintiff is silent as to when he has handed over possession. Sale deed is clear that he has handed over possession. He is silent about the fact, if he says that he has handed over possession over a particular plot of land and subsequently I have shifted, then the matter is different. It is not his case that he has given possession over one plot of land and I have shifted to another plot of land. It is not his case. If your lordship desires, I can take your lordship to a specific paragraph of the claim. He is silent about the handing over of possession. He is suddenly saying that they have trespassed over 3 bighas of land. What about the sale deed, my lord? Sale deed clearly says that you have handed over possession of 2 bighas of land. Now, if I say that I have entered into possession of this land and I have started construction, after 1 year, can you raise the objection, my lord? That is the issue to be decided in the prima facie case. And so far as the other two, my lord, lordship is aware, the Honorable Supreme Court has made it clear on several occasions that mere establishment of prima facie case will not entitle the petitioner to the grant of a temporary injunction unless he establishes the other two. So far as the irreparable loss and injury is concerned, as I have submitted, my lord, if today injunction is granted and for 1 year the injunction order remains, all my machine will get trusted, my lord. Is it not the issue to be discussed? I am not saying that the lordship will discuss, but the learned trial court should have discussed this issue for the purpose of coming to a finding that the principle of irreparable loss and injury tilts in favor of the plaintiff petitioner. There is no discussion. So far as the balance of convenience is concerned, my lord, there the discussion should have been that why did you not approach in the beginning when the boundary wall was given? Why did you not come to the court when the installation of the machineries, etc. was undertaken? You are coming after 1 year when everything is over because your application for grant of similar license is now ready, and once I have established, you will not be able to establish your one. That should have been the issue to be discussed under the heading balance of convenience. That was not discussed. This is my submission before lordship. These are the real subject matter to be discussed in the when the application under Order 39 Rule 1 and 2 are considered. And environmental issue has become a major issue that it will affect the environment. The plaintiff never says, and plaintiff cannot say also. He is not the protector of the environment in a civil suit, my lord. And lordship will kindly see the court has, my lord, the court has preconceived, because my learned friend who used to visit Tejpur, my lord, for moving this petition, he was repeatedly asking the court, kindly dispose of my machines are rusting. The honorable court delayed the matter about 6 months on this plea or that, and one of the pleas, the plaintiff has filed an application for amendment of the plaint. And that is a completely different issue. For that, the court should not have waited for the disposal of the temporary injunction matter. Now the court justifies it and says that none of the parties has shown any urgency in the disposal. While the court is discussing and devoting 6 pages of its order for the purpose of, my lord, meeting the requirements of Order 39 Rule 3A, that if it is not disposed of within 30 days, reasons are to be recorded. Now, court is recording reasons and then it says that nobody has expressed any urgency. That is why I could not. My lord, that, my lord, nature, I will humbly submit, my lord, the lordship will permit me that court has passed the order with a preconceived notion that court will dismiss my petition. I'm submitting because court has taken up certain issues, my lord, which are not relevant at all.
Maybe may not be relevant, but attributing oblique motive upon the court is.
No, I'm not, personally, I'm not saying anything. Personally, I'm not saying anything against the presiding officer. What I'm saying is, my lord, when we are urging, my lord, for early disposal of the court has taken up an issue of amendment of the claim, which should not have been taken up, my lord. That is my submission, my lord. There the delay has occurred, and that was an absolutely irrelevant issue, my lord.
Anyway, let us admit the appeal.
And my submission to your lordship will admit the appeal and pay the operation of this order. Otherwise, my lord, this will again, my lord, I have spent, lordship has seen, admittedly, I have spent few crores, my lord. And now the injunction has been granted without considering as to whether this expenditure that I have made, that shall come in the way of grant of injunction.
Under order 43(1)(r), the code of the order dated 4/8/2025 civil judge senior BTEC or 14 of 2025. It is here that by civil judge senior as direct the party that heard the memo by the ground that ethic it's after 4 weeks. In IA we will pass the order.
My lord, yes. My lord, in IA, my lord, my
oblivious. Yeah,
my lord, lordship today is issuing notice in the IA also.
Yes, notice will go.
Yes.
But regarding the stay,
My lord, if your lordship is staying, my lord, is
no.
I'll pray. Otherwise, your lordship may issue notice, making it very clear that on the next day this IA will be considered.
No. Today I will consider the interim here. But after going for the client and the topic.
My submission is, if your lordship is not satisfied to grant an interim stay at this stage, lordship may issue notice in the IA. And if your lordship grants an injunction, it's all right. Otherwise, your lordship may.
Will say.
Smile.
Next slide.
May it pleases your lordship. Lordship, may the matter kindly be adjourned for the day. My senior had to leave the court due to domestic
Who is
urgency.
your senior?
He had to leave the court due to domestic urgency, lordship.
Who is your senior?
Mr. G. Portoloy.
Art means your good name?
L. Izum.
Please the matter.
May I please, your lordship? My lord, when the matter came before the Lavazma court, it was found that service is complete with regard to respondent number 181D, my lord. And then I was given 7 days time, my lord, to search about the address of respondent number 2 and 3, and then to, my lord, take a steps. My lord, in fact, within a week, the steps was not taken, but it was taken on 29/1. And as of date, my lord, there is no service report. So if your lordship...
For order dated 23rd the Housing Accord. The current directed take step of within a period of 7 days. You could not take steps.
Within 7 days, I could not take, my lord, but I took the steps on 29/1/2025.
29/1
2025. 8/1 was the order, my lord. I took it say after 20 days.
How about Mr. Tucker for the abstain? Though he could not take sleep of the resolution number 20 in 7 days, yet he has taken sleep of both 25. But till then, service report is made available. What to do? You want to take Francis?
My lord, I may be allowed to take fresh.
Mr. Tucker understand he may be allowed to take fresh sleep or allowed to be taken by letter book with alien also by the process from them. This is the matter after for it.
Pleasure.
My please note dated 21/2/25 reflects that the notice sent by this court was returned unturned. Due to insufficient redress. My lord, I am permitted to take the steps by Dusty.
Dusty. Or sir, are you more for the application of 2020 it's then notice to the resolution number 1 return report with an inverted comma insufficient address return to the center. Some more summits that he may be allowed to take step above the resolution number 1 and by Dusty. That is economic after effecting service after response number 1 and by Dusty. Fine. An affidavit for this on next is a matter after 2 weeks or 4 weeks.
3 weeks.
3 weeks.
Maybe Lordship, initially RSA was filed, Lordship, but the Adelaide Council had withdrawn it. When the appellants come to know that no such instruction was given, he again filed the restoration petition, and after hearing both the parties, RSA was restored. But there were sufficient delay, Lordship. There are some of the appellants filed. So, Lordship, this IA number 1362 of 24 is the condonation petition. And other two numbers of IA are for setting aside the abatement and the first substitution of the lien.
What is the period of delay?
Period of delay is in respect of Lordship, the appellant number 1, the delay is 5255 days. And for appellant number 2, Lordship, delay is 173 days. And for appellant number 6, Lordship, the delay is 5810 days. And for appellant number, Lordship, 8, legal years are already on record.
What is the ground for delay?
Ground for delay, Lordship, they are resident of Silchar, Lordship. Most of them are illiterate, Lordship. And they had initially no knowledge that the RSA was withdrawn by the London Council without their consent, Lordship. And when I was engaged, Lordship, and went to the case report, Lordship, the most of the appellant numbers were not available. Then I contacted one Sunil Nath, Lordship. Then he come and furnished the names of the legal heirs, Lord. And due to this COVID, And ultimately, when I am not receiving any instruction, Lordship, I have issued a retirement letter. Thereafter, one Sunil Nath turned up and he gave the details. So that, and
In which part of your application,
Lordship, yes. Retirement letter, Lordship, I have page annexure 1, Lordship, which is available at page 16 of the condonation page.
My lord, yes, I have already filed objection. My lord, if it is in record, my lord. But the delay regarding appellant number 5,000 days, my lord, about more than 5,000, and 6 more than 5,000, my lord, 5,815. Yes, may submit, my lord. May submit. My lord, the second appeal was withdrawn by order dated, my lord, 18/8/2014. My lord, thereafter, the restoration petition was filed, my lord, in Miss Case number 1271/2015, my lord. This is the Miss Case, my lord, for restoration of the second appeal, my lord. If your lordships take the Miss Case number 1271/2015, there are some facts, my lord, disputed facts, my lord. Appellate number 1 and appellate number 6, my lord, died long before. That is, my lord, before filing the restoration petition in the year 2015. And restoration petition 1271/2015 was filed, my lord, executing the Wakalatnama, my lord. The 12 known persons, appellants. Some of the name is not in the record, my lord. The present IA, my lord, also. That IA, my lord, subsequently, my lord, in the by order dated 16/2021, allowed, and second appeal was restored, my lord, by this honorable court. And subsequently, my lord, thereafter, one IA number, my lord, 175/2018. That I was filed by the appellants, my lord, for substitution of the legal heirs of respondent number 1. That is myself, my lord. Respondent number 1. 175/2018 for substitution of legal heirs of respondent number 1, my lord. But till filing the substitution of respondent number 1, 175/2018, no substitution petition was filed, my lord, to substitute the legal heirs of appellant number 1 and 6. And 2 also, my lord. 2 subsequently died, delay is 172 days, my lord. In that IA, my lord, for substitution of respondent, legal heirs of respondent number 1, appeal in the cost title, if your lordships will find in cost title of this IA 175/2018, it is clearly, my lord, recorded the age of respondent number 1, that is 55 years. Although respondent number 1, my lord, had expired on 29/7/2007. And in case of appellant number 2, my lord, age was mentioned 46 years, who expired on 18/1/2006, my lord. This most interestingly, my lord, in the affidavit part of this IA 175/2018, appellant number 2, my lord, create the affidavit, my lord, who swear, my lord, on behalf of other appellants, my lord. Affidavit was sworn, my lord, by the appellant number 2 on behalf of, with due consent, my lord, and authorized him on behalf of other appellants. Where appellant number 1 and 6 and also 2 has died long before, my lord. My lord, dead person cannot, my lord, authorize appellant number 2. This is my understanding, my lord. And my lord, restoration petition, my lord, IA 1271/2015 was filed by my learned counsel, my lord, without filing the substitution petition, and even not mentioned in that IA for restoration, my lord. There is no any statement that appellant number so and so was died. Ukalatnama was filed, my lord. 12 noms of persons, my lord. I have not found, my lord, some of the name matching with the record of this present second document.
No, no,
As well as
their
the
legal
IS
heirs
one.
are already on record, Lord.
So I have clearly, my lord, stated in my objection, my lord, point wise, my lord, very clearly I have stated. If your lordships, can you go through paragraph 4, 6, 7, and 8 of my objection, my lord, your lordship will found everything here, my lord. The explanation, grounds explanation explained by this, my lord, in this IA, my lord, neither sufficient, my lord, nor cogent, my lord, to condone the delay, your lordship. And the second appeal is pending since 2005, already 90 or more than 90 years, my lord, 19 years, my lord. Initial suit, my lord, in the year, my lord, 1997. And it is against the concurrent finding, my lord. In the title suit, my lord, there is no any prayer for right title interest, my lord. Nothing. Basically, my lord, on this ground, my lord, both the courts below, my lord, dismiss the.
No, you're not.
Yes, my lord.
The
Yes,
merits
yes.
of the
Yes, yes, yes. My lord, I have just submitted. my lord.
Here, examine the
Yes, my lord.
sufficiency of the
Whether sufficient cause is, my lord, explained or not in this IA, my lord, for condonation of delay of long case, my lord. Use. In the year 2014, my learned friend sent a letter to withdraw himself from the case, my lord. In the year 2024, before 24, so many times was listed, my lord, these cases. And in the year 2018, appellant number 2 filed IA for the substitution of respondent appellant number 1, my lord, 2018.
My lord, I was not receiving any instruction. That's why I had served a retirement letter.
Lordships, kindly go through the IA number 1271/2015 as well as, my lord, IA number 175/2018. The lordships will find everything. Signatures in Okalatnamas and, my lord, everything, my lord. Affidavit in affidavit part, my lord. Appellant number 2 clearly, my lord, stated yes, duly authorized, my lord, by other appellants. Whereas other appellants number 1 and 6 have already died, my lord, long back.
second offered restored the file.
My lord, second appeal. Subsequently, my lord, it was restored without filing any substitution petition, my lord. Directly filed the restoration petition by signing 12 noms of persons, my lord. That was submitted, my lord. 12 noms of person I have seen, my lord. Some of the name, my lord, I have fairly submitting, my lord, not found, my lord, in the record, in IA as well as I don't know who signatures of those 12 known persons.
Here the evidence, I think. Allow this application
Up to your lordship.
part as we know it are of the applicant. Sir,
T shake, my lord. T shake, my.
we are not responsible for the by part by the of of A more than 5,000 5 days for the applicant part one. Number B, 176 days. Number 3, 5,110 days. Number 6, 5 days. For bring on record that Roy. So Roy, where you have explained the reason? Where you have numbered?
Regents lordship. Start from page. From page 3 lordship para 2 onward. Sorry, page 8 lordship para 2 onward.
Roy started
From para 2 to lordship para 12. I have.
the ground for delay in filing the application claim in paragraph part 12 and so he made several attempts to correct the application or submit the correct that the delay and that the already under such so it started application allow this paragraphs or on part the count delay has not happened. And has filed an affidavit raise objection in constitution or have heard of society of or the greater than of that of the objection filed by parent or 8 or 6 of the part considering the explanation so provided that it court that the delay by the delay in filing the by the bit for bringing on record the legal errors of appellant and subsequently explained according to the terms of high. So Roy, you have to file amended post title in the RSA.
Yes, yes, Lord. It has been amended.
It has been or you have to.
Oh, okay, I will supply.
In terms of the order passed in this I 136 of the 24. Provided that however, appellant files a complaint are within a period of 1 week from this complaint.
Last slide.
There are two other ayahs.
Yeah, please, Your Lordship. The last location, Lordship had pointed out the order which has been impugned in this particular revision petition. The fact is that, Lordship, before going to the impugned order, I'm just referring to the application which was filed before the Learned Trial Court. Now, when the matrimonial suit was filed, matrimonial suit was filed, Lordship, for the nullity of the marriage. The concerned respondent number 1, the wife, this in the main suit, title suit matrimonial, she had arrayed all the petitioners who are the father-in-law, mother-in-law, and other relative in the suit, who are having no nexus with the issue that was raised in the matrimonial dispute. And there's a dispute between the husband and wife. The other relatives, even the person who made necessary arrangement for the marriage between the two persons, she was also been made as a party to the proceeding. So I filed an application, Lordship. This application I have annexed. It is at page number 20. So Lordship, kindly see this particular application. Page number 16, Lordship, the first annexed here. This application was actually filed for striking out the names of the petitioners, Lordship. In this particular application, it has been mentioned that the petitioner, Lordship, got it, page number 16.
What is the plaint?
Plaint is the additional affidavit which has been filed, Lordship. It is there in the record.
Page number.
Yes, I'm just referring to page number 55, Lordship.
50?
55.
What are the relief being sought for?
Yes. The prayer portion, if your Lordship kindly see the prayer portion, it is at page number 83. Not Lordship, not 83, it's page number 78. For a decree for dissolution of the marriage between the petitioner and the respondent number 1, by granting a decree of nullity by dissolving their voidable marriage, fraudulently solemnized on 34/2024, for declaration that the petitioner is entitled for marriage expenses of rupees certain. So this is the basic relief that has been prayed before the concerned court. So no relief.
Yes, who will pay this amount?
Alert.
Who will pay this amount?
Respondent number 1. It has been mentioned as respondent number 1, Lordship.
It is mentioned as respondent number
Respondent
one.
number 1.
Respondent number
One.
1. Then why the other parties were arrayed in this application?
My lord, what happened in this case, my lord? This suit is filed for nullity, my lord, by the wife. And my lord, on the ground of playing fraud and my lord, concealment of all the facts, my lord. Because what happened, my lord, the husband, he was suffering from mental disorder, my lord, as well as some other disease, my lord. That fact was concealed, my lord. And my lord, in the plaint, if lordship go through the
Tell me
statement,
whether you have claimed any relief against those
relief is not claimed, my lord, but a specific role is.
how they are necessary part.
Well, they are not necessary party. Even the trial court has held that they are not necessary party, but they are the proper party, my lord.
How?
Because the specific allegations are made, my lord, against them, my lord. Each one of them, my lord. Who has played the what role, my lord, and how the fraud was played with the petitioner, with the plaintiff, my lord. My lord, how the things proceeded and how the everything is concealed. And by playing fraud, this marriage was solemnized, my lord. My lord, if lordship goes through the plaint, my lord, the allegations, my lord, if lordship may come to page 58, my lord, that is the relevant portion of the plaint. My lord, I am reading paragraph 3, my lord, page 58.
Not necessary. How they are proper party?
My lord, there is a specific reading in my plaint that who has played what role and how they have concealed all the facts of the mental disorder of the husband, my lord, who is respondent plaintiff defendant number 1 in the suit. So everything is concealed and it is
Unless any relief is being claimed for against them, what purpose will be served by arraying them as a party in the proceeding?
my lord, this is not a pure, my lord, divorce proceeding, my lord. I'm saying that this is a nullity, my lord, and nullity is because there is a fraud played upon the plaintiff, my lord. Because they have concealed, my lord, all the facts, and these all the persons have assured the plaintiff that everything is all right.
Whether to decide the issue of nullity, their presence is necessary.
My lord, my submission is that since specific allegations are made against them, my lord, and my lord, as well as there is prayer in the plaint and separate petition is also filed to call for their call details and all this, my lord. So they are the proper party, my lord, although not necessary, but proper party, my lord. Because specific allegations are made, my lord, and even if I made an allegation against any person without making him in a party, my lord, that will not be, my lord, as per law, my lord, because allegations are there against each one else. And my lord, trial court has considered all the things, my lord. If lordship may come to the impugn order, my lord. My lord, that is at page, it starts from page 25. And my lord, relevant will be, my lord, page 28 onwards, my lord. If lordship may come to page 28. May I read, my lord? I am reading from paragraph 8, my lord. In the, may I read, my lord? May I read, my lord? In the light of this established legal principle, this court must examine the pleadings submitted in title suit number 204/24. It is apparent that this petition has been filed under section 12(1)(a) and (b) of the Hindu Marriage Act for a declaration that the marriage in question is null and void. The assertions made by the petitioner clearly indicate that there are specific allegations against all the respondents, and it is the petitioner's obligation to substantiate these claims by presenting evidence that proves the marriage is voidable or void due to alleged fraudulent conduct by the respondents. For the sake of brevity, this court will refrain from reproducing the detailed contentions of the plaint. It is, however, noted that the petitioner claims that respondent number 2 to 12 were actively involved in the solemnization of the marriage to respondent number 1. This allegation must be supported by evidence in the course of the civil proceedings. Counsel representing the petitioner and respondent 2 to 12 have presented a compelling argument before this court, asserting that the petitioner has not sought any relief against respondent number 2 to 12. Consequently, their inclusion in these pleadings is unwarranted and their names should be struck off from the record. Counsel for the petitioner has further argued that respondent 2 to 12 were included solely to impose harassment and are not necessary parties in this matter, which justifies their removal from the plaint. Conversely, counsel for the petitioner, OP has strenuously contended that specific allegations have been levied against the respondents. It has been asserted that the consent obtained for the marriage between the petitioner and respondent number 1 was acquired through fraudulent means. Given this context, the necessity of the respondent's presence has been underscored. In light of the submissions present by both the counsels, this court has undertaken a thorough examination of the pleadings on record. The original suit was filed to declare the marriage between the petitioner and respondent number 1 as void. Citing allegations of fraud against the respondents in the context of litigation, parties can generally be categorized as either proper parties or necessary parties. Order 9 specifies that a suit cannot proceed in the absence of necessary parties. The involvement and submissions of all parties are essential for the court to adjudicate the principal issue concerning the disputes as determined by the relevant civil court based on the pleadings between the parties. Upon review, this court determines that the petitioner has made a specific allegation against the respondents and has sought relief against the respondent number 1. It is clear that respondents 2 to 12 are indeed proper parties and their participation is necessary for a comprehensive examination of the alleged fraud and other related claims. The burden rests with the petitioner to substantiate the allegation of fraud and alleged active role of the other respondents. Until such claims are...
Mr. Gupta, you tell me What is the justification for being proper party by the respondent number 12?
My lord. My lord.
Where is the explanation? What is the reason?
In the
for being
plaint,
a
my lord.
proper party?
In the plaint,
Clearly
my
saying that they are proper party. Is it sufficient?
my lord, in the plaint, my lord, if lordship goes, my lord, we have the plaintiff, there is a specific allegation,
No,
my
in
lord.
the order.
My lord, it is further there, my lord. Furthermore, the allegations directed at respondent number 2 to 12 afford them an opportunity to address the claims made against them, to ensure equitable adjudication, and to arrive at an informed conclusion regarding the dispute. This court concludes that the continued presence of respondent number 2 to 12 as party to this case is essential. Therefore, their participation is deemed necessary for resolving the matters at hand. Furthermore, this court as a civil court is obligated to hear from all parties against whom allegations are made in the pleadings. In the present case, the petitioner OP has articulated a specific allegation against respondent number 2 to 12. If the court were to dismiss their names at this stage, it could lead to prejudice in any determinations made upon the conclusion of original suit. In light of the aforementioned considerations, this court is compelled to conclude that respondent number 2 to 12 have been duly and properly named as party to the suit, and their presence is essential. Accordingly, the request present by so and so lack merit.
How they are proper party? What is the explanation?
My lord,
What
it
is
is,
the reason?
my lord, reason is assigned, my lord, in paragraph, my lord. My lord, 12 and 13, my lord. Twelve, 13, and 14.
No, it is only stated that it is clear that respondent number 2 to 12 are the proper party. But how?
So since specific allegations are made, my lord, and my lord, since the fraud is there, my lord, the consent is taken by playing fraud. It is not that, my lord, something other is there. Since the fraud, how it was, everybody has played their role. And my lord, already the proceeding is, they have not submitted their written statement, and already the proceeding is ex parte against them.
That is a different matter.
What has happened, Lordship, on the last occasion when I moved this revision petition, Lordship, there was no stay orders. Filed an application before the concerned court. Since the matter is pending before this court, so kindly allow some more time. Since the written statement, we are not been in a position to file the written statement. Even that order was also passed against the petitioner's lord. Since the revision petition was pending, so the stay order was not there. So I moved an application before the concerned court, saying that since revision is pending and there is a prayer for stay of the proceeding. So in that view of the matter, so no coercive order should be passed. But that order has been passed. Proceeding ex parte against the petitioner. You are allowing this, the rejecting our application for striking out. At the same time, you are rejecting our prayer for filing the written statement. So you are saying in the impugn order, it has been mentioned that no prejudice will be caused. At the same time, causing prejudice to the petitioner. Lordship has rightly pointed out, no relief has been claimed. Even in the prayer portion also, the wife is claiming relief, the compensation from the husband. She is otherwise not claiming any compensation from the other person. And what is the use of impleading all those persons in the proceeding? It's a matter of trial. She has to prove it. Mere incorporating the name of the other person is nothing but the abuse of the process, just to cause some sort of harm, just to cause some sort of mental pressure upon the other person's law. So this application, Lordship has pointed out, there is.
You tell me whether to cite the issue of fraud, their proper party.
No way, Lordship. It is for the petitioner to prove that aspect of the matter. Mere allegations. These are allegations. That too, Lordship. The first case was filed by the husband. After the husband filed the case for divorce, then only she filed the case. Just certain story has been made out. Lordship, I have annexed both the petitions, Lordship. The first case was filed by the husband for divorce on the ground of cruelty by the wife. After receiving that notice, Lordship, then she filed the case. Now she has added all the father, mother, and everyone, Lordship.
Whether that petition is a part of this.
Yes, Lordship. This is Annexure A, Lordship, page number 33. The first application was filed by the petitioner, Lordship, the husband, Lordship.
Page number?
This page number, this one 37, Lordship. petition for divorce, page number 38. That was the husband who filed the case for divorce on the ground of cruelty by the wife. Now, as a counterplus to that, she filed the case. Now she has this arrayed all the persons, father, mother, then sister, then brother-in-law, all persons, all relatives. Even the person who had arranged that marriage also. This is nothing but absolute abuse of the process of court law. I mean, there is no whisper on the part of the petitioner, this wife, as to why these persons are required. Merely saying that they have done something, then why you have not paid for some sort of compensation? If the conspiracy was there, why there is no criminal case against those persons? Merely saying in the divorce proceeding, and that too as a counterblast to the other petition which has been filed by the husband, is apparent. This is an abuse of the process of court. The learned trial court, while rejecting the petition of the petitioner, has not dealt with all the issues which has been taken into account, which is to be taken into account by the trial court. Because in the petition we have made out, we have specified each and every aspect of the matter. Why the petitioners are to be related as a party to the prosecution.
So the allegation of fraud is on your part. So you have to discharge the burden.
Yes.
So what they will play the petitioner of this case
My lord,
in establishing your plea.
because I have alleged that they so and so has done this thing, so and so has done these things, my lord.
This is not a criminal proceeding.
No, yes, my lord, that is not a criminal proceeding, but let them say what they have done, my lord, whether they are admitting or denying, my lord. Because I have
How
made,
they are admitting or denying will help you.
because my lord, I have to prove the fraud, my lord, and that's why they have made the
Burden.
party.
You have alleged.
Yes, my lord, I have to prove the fraud because in their absence, my lord, if I made any allegation in my plaint, my lord, then my lord, in their absence, it will be difficult to, my lord, substantiate all the facts. Because my lord, I have also paid that the call details and all the of all these persons to be preserved and will be called at my lord appropriate time, my lord. And to that effect, my lord, application is also filed. That is also on record, my lord. But page 81 is the application filed, my lord.
Or Rudy,
Okay. May I please, my lord? Lord, this is a appeal under the Motor Vehicle Act by the owner of the vehicle, my lord. My lord, in this case, my lord, there is order of pay in recovery, my lord.
एक आकृति लोग for respondent number 4 लोग
एक
आकृति 4 लोग
direct the order. Hospital under the member or the award directed the appellant hearing. Directed the OP number 2 pay the compensation of 1,070 and also directed entered at the date of 8 per the date of filing the claim with DLA and order of that after payment the P number 2 the insurance company is liable to be first by the driver that booking for Kumar the compensation amount with the well pay the pay that for the memo by the so what is the what is I think you are appearing for respondent number
Respondent of 4 lots.
number 1 over offerment not required to for over extradition of the this is the for the record
My lord, I have a IA, my lord. My lord, I have filed one IA for stay, my lord. What happened in this case, my lord? If lordship may come to page 11 of IA, my lord. Page 11, my lord. My lord, order dated 19/5/23, my lord. Claimant and OP number 1 represented by learned advocate seen and peruse the case record and petition number so and so filed by claimant and filed by OP number 1. Claimant did not file Form 54, hence the instant case is kept in abeyance till arrival of Form 54. The case will be put up after submitting Form 54 by the claimant side. My lord, then by this order, my lord, the case was kept in abeyance, my lord. Then, my lord, at page 12, my lord, on 28/6/23, Form 54 was submitted. But at that time, my lord, due to some mistake, notice was not again issued, my lord. That's why this appellant is ignorant about the proceeding and the proceeding proceeded ex parte against him, my lord. So this is my first ground of appeal that although it was initially notice was issued, but since the case was filed, so at the later stage, my lord, no notice was issued, so that's why he has not appeared before the tribunal. And my lord, the case proceeded at ex parte against him, my lord. And my lord, second ground is that, my lord, the tribunal has found that insurance is there, everything is there, but only since there is allegation in the FIR that the appellant was driving at the time in a drunken condition. That's why the tribunal has, my lord, passed the order that the insurance company should pay the award and recover. But whereas, my lord, in the written statement of the insurance company, there is no whisper about the drink and drive. And, my lord, apart from that, my lord, there is no evidence adduced by the insurance company. Nothing is there to prove that the appellant was driving at that time in a drunken condition. If lordship may come to the, my lord, relevant portion of the judgment, my lord, page 20. My lord, only problem, my lord, writ is already issued, my lord.
Or?
They have filed the execution case. And, my lord, already writ is issued. I have annexed the order, my lord, at page 28 of IA, my lord.
Whether the insurance company has paid the
Yes, my lord, they have paid the amount and claimants have already withdrawn the amount.
Already paid the amount, Lordship, and the claimant also withdraw the.
Also already have withdrawn the amount.
Lordship, the stay may be given, but subject to the deposit of the all amount. Either in the tribunal below or registry. Because insurance company already paid the amount, Lordship, and the same was received by the claimant, Lordship. And
Lordship, the learned friend has been said that no notice has been issued, Lordship. In the eye of page number 13, Lordship, that is order dated 1/9/2023, Lordship, page number 13. The order is clearly reflect that the notice has been returned after service, hence the case will be proceed ex parte against the OP number 1, Lordship. As per the observation of the trial court below, Lordship, the notice was duly served by order dated 1/9/2023, Lordship.
At least 50% of the awarded.
My submission is that, my lord, there is nothing, my lord. So let notice be issued at this stage, my lord. Let him file objection what he wants to say.
Applicant or order for 5 take the order, take the judge award additional 30. As well as the order dated 25. Like, if the case number that not no formal how extra type of it or is the
Oblige.
Item 21.
Well, with due permission, we beg to mention item 43 of supplementary list, my lord. It was not taken up already, my lord. But it was directed to list after a week, my lord. If it is after a week, my lord, then on 20, it was, my lord, date of fixed for execution, my lord.
Yes, we have all the matter, no one entered.
Yes, my lord. Due to, my lord, waterlogging, we could not reach in time. My lord, can it be, date may be fixed, my lord. No, I am not saying that today it taken up, my lord. Date may be fixed on 18, my lord. 18 Monday, my lord. 18 August. Oblige, my lord.
My lord, in this case, Lordship, I am for the respondent, Lordship. I should to file objection, Lordship, regarding the condonation of delay. I need some time, Lordship.
Which matter?
Item 21.
21 is the FAO.
FAO, Lordship. There is a delay of
I is there.
Lordship.
Okay, where is the I?
In my
Part is the proper card for the applicant and also part for
K. Majumdar, Lordship. K. Majumdar.
card.
Lordship, I may 10 days time, Lordship. It's from Hailagandhi, Lordship. I should have to send it.
After
March, July.
May I please your lordship? Before proceeding, my lord, today, I filed an IA. What happened, my lord, during pendency of this RSA, this was dismissed for default, and we filed for restoration. There is a delay. That is also we have done, but upon response number 9, not its completed service report. But in the meantime, what happened, my lord? Title execution case is started. No, going to be started only anyhow today, tomorrow it was there, honorable judge is not there today, but I am filing IA during pendency of two. Today I is not available today because though I have filed on Monday itself. That's why my prayer will be let matter be fixed on Monday, my lord, along with IA. I'll give my filing number and all.
That IA is for
Stay of execution because this pendency of days is pending.
appeal is yet to be admitted.
Yeah, my lord, because no, appeal is admitted. RS was listed for hearing. It was regular hearing. Whatever this is, my daughter was sick. This I was in Delhi.
It's IA, present IA.
IA
IA number 2464. It is for what purpose?
2264.
So it's for delay.
There is delay, my lord. This file is not yet to come. That IA is yet to come. Friday, Monday, I have filed it. But that is why my prayer that may be tagged along with this and may be listed on Monday, my lord. I can. Or lordship, please add that day Monday after going to my
No, RSA has been dismissed for default.
default. That is when it was regular hearing. Thereafter, we have filed for restoration. But restoration, there is a delay. We have filed in condemnation petition. That notice was issued on condemnation petition. But upon response number 9, it is still waited because she had died. She's died. That is why we are searching for his name. Address is being also changed.
Guru attorney for the application.
As Gautam, your lordship.
As attorney.
2, 4, and 5, your lordship.
That is filed on application for delay of
Left manage like 494 days, Miller. There is a 494 days delay.
494 days delay.
Delay in filing restoration petition.
Restoration.
My lord.
That the state IA is not passed before this.
No, my lord. This IA is there. During this, I have filed another IA for staying the execution that is yet to be tagged with this one. Monday only filed. My prayer is that newly filed IA should be tagged with one. Along with that, it should be listed on Monday.
Sir, Guru, your RSA is not the file now. It has already been dismissed.
No, that is why.
Then unless IA that RSA is restored to the file, no mistake can be done.
Yeah, we are not there. At least your lordship, my application comes on that day on basis of that my application at least because already I have mentioned them that I have filed one IA. That is maybe on Monday, my lord.
IA for saying
Monday.
for saying execution.
The meanwhile, my lord, I would like to file my objection also. Objection to the delay, your
That
lordship.
IA is not for the court now.
The IA for delay is there. The stay petition is not there, your lordship.
That is
It is provided that the matter on
Monday.
Monday, my lord.
Monday.
Wednesday. Oh, fine. Fine.
Along with the IA.
My lord.
In the meantime, Gautam Garnet from the opposite party may file the objection.
My lord. Obliged.
My lord, in respect of the present case, my lord, respondent number 2 to 10 entered appearance, filed their Galatama. Respondent number 1, service thus returned back, my lord, with a remark that address is left. So today in the morning, I informed from Raju Goswami, my colleague, he has informed me that the office has changed from Ulubali to Ganeshguri. So I'll take fresh step now with new address.
Third Mr. Talukdar Garnet.
3 to 9, my lord.
NI for 10, OP number 10. OP number 10. Mr. Talukdar submits that you will take responsive upon the number 1.
With new address.
Granting sometime after following step be taken up number 1 by 18. List of
24. Sorry, my address it will be changed, my lord, with new address. This may be.
Take it.
Yes.
May I please, your lordship?
Lordship, we are directed to take steps upon respondent number 5 through justice service. My lord, the petitioner went to the office of the respondent number 5, but the petitioners were asked to get out from the office. And then on 19/7/2025, petitioner went to the officer OC before OC of Dhemaji police station to accompany some police personnel and to serve the notice upon respondent number 5. But due to no order from the honorable court, so no police personnel were accompanied to the petitioners, my lord. My lord, Annexure C is the affidavit.
They have refused to accept notice, they will file an affidavit to that effect.
Yes, my we have filed the annexure is the affidavit, my lord. We have filed the affidavit also.
When?
My lord, 4/8/2025. My lord, 91, page number 91. Para 4, my lord.
The Coco Eva for 1 to 3.
1 and 3, Lord.
1 and
Lord.
Lordship, I appear on behalf of respondent number 6. Yes.
which respondent for
The respondent number 6 is the owner of that particular resort. Lord.
her sir?
Please say, my lord.
Lord, uh, here go
Lord.
for 1.
And Sharma, your lordship.
Oh, Lord.
6.
Of the office dated and the affidavit made by the dated 4/8/25 service of 5. What about the respondent number 2?
Well, complete, my lord. Yes, my lord.
When? What is the report of service of notice of resolution number two?
My lord, for respondent number 2, the standing council forest will appear.
Yes.
Yes, sir. Well, their name is shown in the copy.
That service already up. That's the list of it.
Well, can it be on next Tuesday, my lord? Next week Tuesday. Well, there is an prayer for stay of the title. 22nd. Much better.
Please, your lordship. As per office note dated 11/8/2025, no service report has received. Lordship, 2 weeks time may be given. We'll take fresh step on all the respondents. Lordship, interim may be continue.
Third miss.
Miss A. Hussain, I'm appearing on behalf of T. Bharadwaj.
Third T versus.
T. Bharadwaj.
T versus. Petition. The learned for the subset or take rest of the state with the be taken by the state.
There's an appeal for announcement of the awarded amount. Also, while filing this appeal, there was a delay of 9 days in filing this appeal.
Third is table. Third applicant. Number.
Respondent 1, lordship.
And the publish was that 2 and 3 already when I entered appearance.
Epic.
Publish.
Five. Deferred by the 8 days. Connected appeal. The word was caused by the third member of the state of was 191 of 2018. It's all learning from the upset. Why the appeal not be filed in time?
Lordship?
Why the appeal could not be filed in time?
Because, Lordship, the petitioner has to undergo so many operation plus he was hospitalized several times. There's we had some financial constraint. So that's why after getting the awarded amount from the insurance company.
Of the help of the appeal. And also for financial not filing time. And is other
Amount.
allow this application.
No, it's the judgment amount.
Of proportional part considering the extent of area of night and for the connected that appeal is put of the day of the and that's the same the order of now the lordship and this report as
May it please your lordship kindly pass over for the date. As convocation is pending, if it is possible, kindly list the matter on Monday. You, Roy, appearing on behalf of R. Chaudhuri.
everything.
One.
Kindly a date may be fixed.
I'm aiming for 5 and 6.
What is that? 5, 6. Dot. That's for on.
Next week, any date?
Last week of August, man. You need it. Last week. Twenty.
May it please your lordship also back to mention item number 39. Item number 39, same prayer.
I'm appearing for the petitioner, my lord, in item 39. As per
Correct. Same prayer.
They had to obtain certain instructions, but their client is behind bars, as I'm informed. So the matter may come up after 4 weeks, my lord. Item 39.
As agreed by learned that of both the bird apart for 39.
39. There is an interim stay, my lord.
Yes, sir.
Highly obliged, my lord.
Much obliged.
May I please your lordship? Subsection 5 of the limitation application, your lordship, for condonation of 137 of delays, your lordship, for preferring and matrimonial appeal, your lordship, against order dated 17/8/2024, your lordship, 137 days, your lordship. The reason of delay, your lordship, to prefer that matrimonial appeal on time, your lordship, due to some mistaken of fact, your lordship.
Pardon?
Due to some mistaken of fact, your lordship, on the part of the engaged counsel of the petitioner, your lordship.
Take of fact.
Mistaken of fact, your lordship. Here you what happened, your lordship? There is 2 cases, your lordship, going on between the same parties, your lordship.
Yes, madam, any objection?
Yes, I am objecting in this case. Normally I am not, but here I am objecting, lordship.
Why?
Lordship, here her contention is 2 cases are going on between the same parties, lordship. She was under the impression that this is the same case she has already filed, lordship. Because it is not, but it is not correct, lordship. That earlier case, that is DV case, which she is mentioning, that was filed earlier before passing the judgment of the present case. Ma'am, the present case, lordship. So after that, in that case, notice was already issued. Thereafter, judgment was passed in the present case, lordship. I admit it, your lordship. And
Because
another contention is that after receiving the notice in the execution case, she came to know about she has knowledge or came to know about the proceeding, lordship. But when she received the notice of the execution case, there is no mention. And from that date till filing of the present application and appeal, lordship, there is no explanation, lordship. So in my humble submission, that lordship, there is no sufficient cause shown in the present application, lordship. 137 days, lordship, and matter relates to payment of decree of permanent alimony, lordship. Since last 1 year, he has not paid a single amount to me, lordship. I am for the wife, lordship. So that other proceeding that was admitted, notice was issued long back, lordship, and filed long back, lordship, before passing of the present judgment.
So then you file an additional affidavit.
Here, if lordship, kindly, with due respect,
What is that?
at least, lordship, some cost may be imposed, lordship, because she is wife, lordship, and she has not received anything since last 1 year, lordship. Yes, lordship, three parties there, your lordship, on marriage, lordship. It is another party. So other cases there, your lordship. While convening that, lordship may impose some cost, lordship.
So on the date of order dated 17/8. Third, third, is the yes, you get the number the learned software product that also income right the part of the not filed inside and therefore it with system of material side or in the case of Pasti Kamanai Niger versus Pansalai Amma CRP ticket N or 105 4 the learned for the also of the participants and then are good point in the it which is part of it. Therefore, the part the topic
I have filed objection also. I have filed objection also here.
and the is not made by the by the having heard the part of the topic topic the part word is to it put it over subject is of and of Adam subject of both of and self is posted of the part where it is
That is Lakhimpur Lordship.
but the case has already been but that case has already been disposed of here.
Then before the registry of this honorable court. Lordship.
The dispute court. Or it's from there. In view of the order passed I now the registry will proceed to register the case in the for the court.
Lordship, registry may be directed to mention my name in the main appeal. Otherwise, my name may not be mentioned in the appeal.
Respondent court. Like part. Appeal.
Obliged, Lordship.
With due respect, Lordship, the cost may be reduced, Lordship, to 5,002, Lordship, with due respect.
No, Lordship, because she is
Because,
not
Lordship, because otherwise my client is
His wife having no income.
hardship, Lordship.
Lordship, he has to come to Guwahati again, Lordship. Obliged.
May I please, Lordship? My lord, as per office note, my lord, 5/8/2025, service is not complete. Neither edit card nor answer notice has been received by the registry. So, my lord, petitioner may be allowed to take a step on Dosti. And a short date may be given. As because, my lord,
But the assignment that is what I hope that is by the learned that part of respondent. In fact, This number. Week or
2
week.
weeks, my lord. Obliged.
May I please your lordship? Lordship, petitioner is filing a IA lordship for early hearing of the MSc appeal lordship. Because of claim number 1, petitioner number 1 is the wife of the deceased lordship. An accident occurred 2015 lordship and suffering from whole ailment lord. Therefore, I is filed for early hearing. Appeal by the insurance company.
No objection, Lord.
Further care for a
Date.
audit
Date.
of MSc appeal number for a learning the applicant operating from
All else ailment lord.
all
Claimant number 1.
ailment. That's the article.
Lordship kindly take the date lord. Before vacation, if possible. 20. Highly obliged, sir.
Obliged, Lordship.
Oh, please, Lordship, my lord, as per direction of this honorable court, my lord, I have filed, my lord, additional affidavit, bringing some documents, my lord, regarding the land under possession of the applicants. applicants. So, my lord, Schedule D, land, which is a land measuring 0.4 katha, 0 liter, more or less, my lord, is under possession of the applicants, my lord. And also, my lord, more or less 5 lesser, my lord, land is under possession of the applicants, my lord, which is described in Schedule E. my lord. So, my lord, this is the land which are under the possession of the applicants. The photograph, my lord, page 26, kindly see, my lord. The power plant machine, 5 horsepower and 1 tree, my lord, value tree planted by the applicants is there, my lord, within the in possession of the applicants. So, my lord, as such is prima facie case, and the balance of convenience is in favor of the applicants.
No, on the other day, you have submitted that you are in possession some of the parts of the
Yes, yes, it is there.
Today you have shifted it to Schedule D.
Schedule D, man. Schedule D is the, my lord, some portion of land of A, B, and C schedule, my lord. The southern part of the Schedule A, B, and C. That is under position of the applicants. Obliged.
May I please, your lordship? My lord, in the IA lordship, may kindly turn the page 12, my lord.
We haven't received the copy of IL. Check into IA, no, her name too is different. Lordship, just though we have not received the copy of the IA lordship, the IA is filed by someone else. The appeal is filed by Syed, no, Syed Jamal. The claimant was Syed Jamal. Now the IA is filed by Syed Razul. So lordship will look into that, whether he is the claimant. No, cause list মানে আমি copies পোৱা নাই নহয়।
একদম ঠিকে আছে সেইটো কিন্তু
Cause
লিখাত
list ভুল আহিছে।
লিষ্টত ভুল হৈছে
Cause list ভুল আহিছে নেকি?
মই লিখাত
আচ্ছা, it seems cause in the cause list it's wrongly printed. So we did not get any copy. You can copy the
Matlab, only issue is that matlab, so far matlab, my understanding is concerned matlab, everything was okay matlab, the other side has matlab, the content of the order is that matlab, it has been directed to matlab, deposited 50% matlab, and subject to matlab, condition that for admission of appeal. And the insurance company has already been matlab, 50% has already submitted. But you may kindly matlab, the registry has matlab, some confusion matlab, as regards to the word matlab, on para 6 matlab. Last word. So far, my understanding, my lord, it is okay. My lord, adjudication, man.
Page 12.
Page 12. Respondent number 1 is allowed to withdraw the amount on proper adjudication. That's why I'm not been able to, my lord, because they are not.
good training. Adjudication. That means after the decision of because I think his appeal is
that they have nothing to adjudicate.
Yes, my lord. My lord, perhaps.
like they do not have.
Otherwise, my lord,
but-
the insurance has do not any objection.
No,
my lord.
Perhaps it was of proper identification.
My lord, maybe.
Uh,
Identification. Alright. Corporate application.
Sir,
Pick it as my lord.
or for the respondent number.
For the respondent number, Lordship. One lot.
Number
OP1.
that's for respondent number
5 plus.
5. Or by the applicant for modification for already ordered then 1 2025 plus I number 5 is number 4 8 1 of 24. Sir, your good name please.
My lord, pick it as my lord.
Pick up. That's correct for the in the IA civil number 408 1 of 2024 by order dated 10/1 2025 court was stay over the award dated 11/3/2022 passed by the amendment of case number 870 subject however to deposit 50% of the award the court and further is to allow the respondent for one with the amount on proper education. The learning council for the applicant further submits that in view of the word used in the paragraph number 6 of the order, the registry is under confusion. Release the amount and as such, the same required to be altered or modified. So that the respondent number 1 may withdraw the amount from the registry. Taking into the submission of current for the person is provided that the word adjudication that has been mentioned in the paragraph number 6 of the order has to be henceforth has to be as identity for all purposes. Not like proper identity. By your PAN card, Aadhaar card, whatever.
Mal. The my lord, in the my lord, perhaps in the cost title, my lord, is in the in my petition, my lord, so far number of my lord, applicant number is my lord rightly my lord there. So lordship may can be possible to direct the registry to correct the name of the applicant. In my lord in cause list they have written wrongly.
Matter যদি petition খন লিখে আছে সেটা matter
Ma'am.
নকৰে I do not have
In petition, my lord, it was properly all offline.
Wait, please, your lordship. This I has been filed for the condemnation of delay of 62 days, lordship.
Okay, 62 days.
62 days.
But that's not it, no?
Yes.
After 4 weeks.
34.
I for condemnation delay, my lord, 247 days, my lord.
47 days. RFA.
My lord.
Let notice go. Let notice go.
Bachale.
Your lordship, this is a delay condemnation petition,
How many days?
32 days.
After 4 weeks.
Your lordship, issue notice. How much only?
But please, your lordship. Lordship, respondent number 1 expired, so 2 weeks time may be granted to file substitution petition, lordship. Respondent number 4 entered appearance and service report is awaited in respect of respondent number 2 to 3.
Go for the
I'm for the petitioner, lordship.
art is
Yes, thus.
as the starting point for the none appears for the respondent number 4, though the name of some of the counted are reflected in the call.
Lordship, I'm really sorry.
Which number?
45. I am for the complaint. 45. Sanjay Kumar Pular কাৰণে মই নহয় 4 নহয় মই yes 4 yes your lordship I'm for the 4.
What is your name?
Your lordship, if I may show you one order of this honorable court in the same case.
I am asking your name.
G.R. Datta.
Here?
Datta.
Here, doctor. That's step number 1. Let upper define. Then granted 2 weeks time.
Your lordship.
Break on record test here.
No, sir.
Yes,
Your lordship, this is what I wanted to submit. For the respondent number 1 who is expired, actually this matter was placed before this honorable court in the year 2019. And in the year 2019 itself, respondent number 1 had expired and they had approached this honorable court for the same. So lordship, may I just show an order? If I may be allowed to show this order. Okay, Drobo. Your lordship, if I may be allowed to read that order. So, your lordship, what is this? If I may be allowed to summarize what is the matter in here, I had filed an eviction suit against the present petitioner 1 and 2.
we are not hearing the matter
No.
of marriage.
No, your lordship, what has happened, not in the merit, I'm not going to the merit. Actually, this petition which they have filed in here, petitioner are well aware that the respondent number 1 is expired in the year 2019 itself. Still, they have filed this instant petition to delay the proceedings. If your honor may kindly see the order dated 8/11/2021, paragraph number 2. The petitioner says challenge the order dated 18 December 2018, passed in petition number so and so alternative. For the purpose of the disposal of the instant petition, the relevant facts are that one, Ms. Gopal Chandra Gopal AHUF represented by Shri Aurobindo Pal since deceased. So this is not something new which has come up today after the filing of this petition. He had expired in the year 2018 itself. That is point number one.
The here the
No, that
break up record.
Your Lordship, that is what, after this was a suit, in this suit, I had filed an impleachment petition whereby because of the HUF, after a partition had happened and the respondent number 4, I was the person who got the properties. And in the trial court below, the other parties are not a party to the proceeding. I had placed an application and my prayer was allowed. So right now only I am the person who is contesting the suit. The HUF is no longer a party. So there is no point in including the respondent number 1 to 4 now. See, if I may just, if you take your Lordship, like, what has happened in the suit. So today in the trial court below, only the respondent number 4 is present. The other parties have been removed from the trial court.
Merely because they have not contested before the trial court. Whether this court is not required, nothing.
No.
Because tomorrow they will come.
No, I had filed. No, actually, I had filed an eviction suit against the respondent number 1 and 2. And during the course of that eviction suit, the property that regarding the schedule 1 and 2 property that has come to my share. And so there is a.
Okay, we will hear you what merit. Sir, let the notice be served.
Lordship, Lordship, there is an interim order that may be continued.
But your Lordship, this case has been going on since 2013. There was a direction to dispose of the suit within 7 months. So they have not filed any evidence since the last 5 days. This is an eviction suit. And now they have actually implicated some person who is no longer there, who is not even a party to the suit. There is a proper order whereby I am the proper, like the plaintiff in the suit. The other 3 persons are not at all a party in the proceedings before the trial court.
Lordship, interim order may be completed, Lordship, in the IA. Yes, Lordship.
May I please, Lordship? Lordship, respondent side has filed Your Honor affidavit in opposition, Lordship. Matter may be fixed for admission.
Okay. Third, Mr.
M. Bora, Lordship.
Learned counsel for the petitioner and
P. Udigiri.
learned counsel appearing on behalf of
Respondent, sole respondent.
Lordship, stay order may be continued.
respondent submitted the part this matter has submitted that product is this the matter for after 1 week.
Lordship, kindly date me fix, Lordship.
Lordship, if possible, 19th of August, Lordship.
Password.
With the license.
May it please, your Lordship.
Yeah.
My Lord, I will take your Lordship first. The chart given by my learned friend, where your Lordship will find item number 2. There your Lordship will find future prospect. Yes.
Yes. Along with this, I have given certain judgment
So,
also.
okay. So according to your calculation, it is 41 lakh 27,164.
No. This was the new one I have already submitted.
They have changed again.
I have
That is-
submitted. Yes, yes.
They have changed, that is also, my lord, on all the items, these are not correct position of law. My lord, I'll just clarify that.
Your lordship, along with the judgment I have given, my lord. Along with the judgment, bunch of judgment along with the.
Those judgment has not been given to us.
No, that is a, I think, on that. Pronounce it is generic. Let me see, my lord. Jagan Sahab. I'll go to- ऐसे, हाँ? Judgment to पैसे. मैं क्या लोग
Now there your lordship will find, total they claim 34,24,840. And your lordship kindly see item 2. Annual income is okay, 1,58,580.
Item number 2 is future prospect.
Future prospect at the rate,
50%.
at the rate 50%.
Yes.
Now, if your lordship look at the judgment of the pronunciatory, if a person is self-employed, that will be 40%. Melody, your lordship may see it. Will be there. So there are two categories your lordship will find in that judgment. Lordship may see the last page. Para 59.3 and 59.4. Now 59.3 will your lordship will find while determining.
Mr. Dotto, not necessary.
Yes.
Not necessary. Anyway,
Yes.
I come to next point.
59.4 your lordship will find 40% because he was a businessman, my lord. Now the second point, that is item 3. He was a bachelor, therefore, my lord,
50%.
50%, they have marked it 1/3 personal expenses. Now, my lord, the latest judgment, your lordship, I am passing on to your lordship. That is say, all along, my
The
lord,
proposition laid in the Sorla Verma has not been changed.
no, it has not been changed. My lord, this has rather fortified that. Because if one is bachelor, then deduction will be 50%. That has been laid down in this Pannalal judgment in 2025.
Right?
So lordship will find that in paragraph 7 and 9. In 9, para 7 and 9, your lordship may see that.
That also not necessary because the law has been settled in the case of Sorla Verma.
Yes, yes. Then, and further, my lord, if they want to say whether 1/3 or 50%, they must file an appeal and or cross objection. That is not there. So therefore, even otherwise, legally also they are not entitled because right from Sharlagar till today, in this Pannalal judgment, your lordship will find, if one is bachelor, then my lord, deduction will be 50%. So there is no quarrel in terms of the law. Now, loss of state, your lordship will find 16,500 into 5. Now, there your lordship kindly see. So for the Megma General Insurance Company, consortium is said to be distributed between the claimants. That will be, my lord, here, mother, then one sister and the two brothers, total 4 in terms of the claim petition. Now, this is only in regard to consortium, there will be 40,000 into 4. But what they are making, loss of state 16,500 into 5.
That also will be covered by the pronunciative case.
Yes, yes. But there, my lord, so far pronunciative case, only Magna has differentiated that if there are, say, 3 claimants, 40,000 into 3.
No, Mr. Dotto, you say pronunciative is the constitutional bench.
Yes, yes, yes.
So definitely it will prevail
It will
over the
work.
Magna
Right,
General
right.
Insurance.
My lord. No, Magna General, my lord, it is in favor of the claimant. Because in favor of the claimant, Pranay Shetty did not, my lord, say that in if there is a, say, 3 claimants or 4 claimants, according
That
the
has not been clarified in.
it is not been clarified.
Yeah.
But in Magna, my lord, the lordship has clarified that if there is 4 claimants, then consortium will be 40 into 4, but not in respect of loss of state or funeral expenses. Your funeral expense is for one time only. Now they want 5 times funeral expenses. The lordship will find that in loss of state 16,500 into 5. Where from they are getting that? It will be 16,500 once only for the loss of state. Only in consortium, again they are saying 80,000 into 5. Where from they are getting 80,000?
No, Mr. Toto, one thing. This loss of this amount.
Loss of state.
Yes.
There is once only, my lord.
That should be increased by
10%.
10% every 3 years.
Yes. So therefore, there
When the accident took place.
accident, my lord, that can be my lord,
2010.
added. 10% will be added every after 3 years.
So you have no objection in that.
No objection because and they have said 16,500. It will be 15,000 in 15,000 once only, plus interest 10% interest every after 3 years. That is the settled position. There is no quarrel on that. Now then, my lord, is not into 5. It cannot be into 5 because loss of state only once, loss of funeral expenses only for one. Only in consortium, my lord, since there are 4 claimants, it will be then your lordship kindly see loss of consortium 80,000 into 5. Where from 80,000 comes? It is 40,000 into 4. There are 4 claimants. So this is also another mistake. Then the funeral expenses your lordship will find 15,000 only once. Then plus interest 10% after 3 years. That is the legal position. Then, my lord, your lordship may see our chart. Point number 1, your lordship will find income of the deceased person taken by the honorable tribunal as below 1,58,800 plus 63,552, taking into 40%, my lord, it will be 63,552. Total is 2,22,432. The number 2, that the deceased was sole breadwinner of the family and he was a bachelor. 1/2 income will be deducted. So deducting so and so, the figure would be rupees 1,11,216. Now, since the claimant is below the age of 25 years, the multiplier would be 18 instead of 17. So we are considering because this is as per law. Now multiplier 18, if we multiply, then it comes 20,01,888. Consortium 40,000 into 4, 1,60,000. Then interest 10% every 3 years, 64,000. Then funeral expenses 15,000 into, my lord, 10% interest will be there. And, my lord, loss of state we forgot, loss of state 15,000 you will get. The total will be, my lord, a bit change will be there. And so for interest on future prospect, that they will not get money. Only addition will be, my lord, 15,000 on loss of state. Your lordship may just mark it. 15,000 plus 10% interest every after 3 years. This will be the precise, my lord, the calculation which they can get.
No, Mr. Doctor, tell me one thing.
My lord.
This consortium,
Yes.
45-4. But it's a paragraph number 59.8. There, the constitutional benches stated that 40%.
40%.
40,000. That has to be increased by 10%.
10%.
every year.
Yes, yes.
But where is the proposition? To multiply it by 4 since the claimants are 4 in number.
Uh,
That is in magma.
That is in magma, ma'am. I'm just furnishing to your lordship. Understand, huh? Your lordship will get in magma, ma'am.
But whether that decision was taken into account in Pranay Shetty?
Pranay Shetty, no. Pranay Shetty, it came earlier, ma'am. After Pranay
Magma is subsequent.
subsequent.
Okay.
This is in Feb.
18.
Your lordship will see from para 21 1 onwards. From 21 itself, your lordship may see. Page 136.
Yes.
The constitution bench of this court in Pranay Shetty dealt with the various heads under which compensation is to be awarded in a death case. One of these heads is loss of consortium. In legal parlance, consortium is a compendious term which encompasses spousal consortium, parental consortium, and filial consortium. The right to consortium would include the company, care, health, comfort, guidance, solace, and affection of the deceased, which is a loss to his family. With respect to a spouse, it would include sexual relations with the deceased spouse. And 21.1, spousal consortium generally defined as rights pertaining to the relationship of a husband-wife, which allows compensation to the surviving spouse or loss of company, society, cooperation. We are not concerned with, my lord, spousal, parental, we are concerned with filial. The lordship may see 21.3. Filial consortium is the right of the parent to compensation in the case of an accident death of a child. An accident leading to the death of a child causes great shock and agony to the parents and family of the deceased. The greatest agony for a parent is to lose their child during their lifetime. Children are valued for their love, affection, companionship, and their role in the family unit. Then your lordship may see para 23. The Motor Vehicles Act is a beneficial legislation aimed at providing relief to the victims of their families in cases of genuine claim. In case where a parent has lost their minor child or unmarried son or daughter, the parents are entitled to be awarded loss of consortium under the head of filial consortium. Parental consortium is awarded to children who lose their parents in motor vehicle accident under the Act. A few high courts have awarded compensation on this. Then your lordship may see the para 25. Para 25, your lordship will find it has been categorized from Roman 1 to Roman 10. We are concerned Roman 10, my lord. Loss of filial consortium, rupees total 80,000 given, 40,000 payable to each of the respondent, 1 and 2.
There were two claimants.
There are two claimants, so therefore 80,000, that is 40,000 into
Okay.
2.
So
Then
in the present case, there are 4 claimants.
4 claimants
Then we have
admittedly.
to multiply by 4.
So 40,000 into 4 plus my lord 10% interest. Then your lordship, I also want to take your lordships to column Roman 8 and 9. Funeral expenses 15,000, loss of state 15,000. It is not that into the claimants, because here funeral expenses once for all. My lord, for whatever, regardless of the religion of the person, it is globally every person death, my lord, funeral expenses is once for all. So in regard to that, they have assessed loss of state 15,000 into 5. That is, my lord, without any basis, that has got no legal sanction. So therefore, my lord, I leave it to your lordships. So far they are entitled, they may get it, my lord, in legally how much they are entitled. Because there is a no cross objection, my lord. But I wanted to say that since they are entitled to get certain things, which legally entitled, they can get. Otherwise, my lord, I could have said I am withdrawing my appeal, but I don't want to do that, because, my lord, they are entitled legally, whatever the law has stated. So, my lord, your lordship may kindly see that.
so they are entitled. But then in regard to my lord, they are saying 50% for bachelor. It is accepted in Sharla Verma, accepted in 2025 also in Pannalal judgment.
Yes, the
Yes.
court says any.
Yes, my lord. So for my learned friend saying about the cross appeal, my lord, I have already given a judgment of the Malapara High Court, 2013 5 GLT.
He has not been pursuing that matter.
No, he has stated that I have not filed the cross appeal and all this.
No, he is not pressing that claim.
Oh, that's why that is okay then. Otherwise, I have given my calculation. But if he's staying on that appeal that we have not filed the cross appeal,
He has already submitted that. He has
then it's okay then. Otherwise, I have given the judgment.
the relief which you were legally entitled.
Yes, I have given the judgment of that submission he has made, my lord, that about the appeal. So it is there, your lordship will go through. And I have given the judgment, my lord. According to me, the calculation is correct. Let them see, because this is 1/3, because sister was there. Out of these four, my bachelor, mother and sister is there. I have given in my calculation. Your lordship will see that. And your lordship will pass the appropriate order. That's because only it is a mathematical calculation, my lord.
Or, sorry,
My lord, one clarification I want to bring. Lord, your lordship kindly see the filial consortium. No. Calculations. That Megma, my lord, I would like to take your lordship. In I'll speak with that. My lord, is a filial consortium, only mother will get. Consortium will be once, my lord, because others are sister and brother. Now, on the death of your children, my lord, the parents get it. Now, here, my lord, the mother is the person who is entitled to get the filial consortium. So only 40,000 they will get, because the younger sister and brother, they are not entitled to get it because it's a filial in nature.
So
therefore
for
it
the
will be-
sister is there, my lord, school going sister, she is dependent. That is I have stated.
No, this is a filial
Well,
consortium.
that
no?
is not saying. Okay, that's it. Just for typing and to go.
Argument on
Mhm.
judgment reserved.
No? You will know?
Sahu for
And
you.
for number 7. 8,222. My lord, in my brother's calculation, there is a typing mistake, my lord. In the calculation he has submitted. No, my lord. The calculation mistake
My
is
lord,
there.
I'll do one thing, whatever he is saying, if there is any mistake, my lord, I'll get it. I do not know, I haven't checked it. If there is a mistake, I'll get it
It is
corrected and I'll submit to your lordship tomorrow with giving a copy to you. I will
Right.
add
That-
this loss of state also, I'll add, and I'll give you a fresh one.
Okay.
Oh, giving a copy to Mr. Bhattacharya.